25.
My lord.
The title execution case has been disposed of
Yes, my lord.
on full and final satisfaction of the decree.
Decree. So that is erroneous because here this order does not take into account the monetary part in the decree which I have just read out. That is at page number, my lord. 37, my lord. Because this speaks only about the, my lord, partition of the landed properties, my lord, immovable properties. It does not say anything about the recovery of the money, my lord, or even the manner in which the judgment debtor will pay the money to the, my lord, decree holder.
No. You are not challenging this order dated 18/12/2025.
We are challenging, my lord.
Where?
We are challenging this. That is why we have put it on record, my lord. Otherwise, why should we put it on record, my lord? We have put it on record. That is how we have challenged it, because we have stated.
No, you come to pair portion of your petition where you have mentioned about this order.
My lord, that has been left out, my lord, due to my inadvertence, my lord. But then the
Inadvertence.
basic prayer is there, my lord. If your
No, it
lordship
is
can
not in
see,
the cause title also.
my lord, it was filed in haste, my lord. I am not sure, my lord. But the basic prayers are there, my lord. The monetary consideration about that, it is there in the prayers, my lord.
Better you withdraw this petition.
I may be given liberty to amend it, my lord. I will amend the cause title, my lord, and file a fresh one.
Not only cause title, you have to amend the pair portion also.
That I will amend it, my lord, and file, my lord. Amended petition, my lord.
Heard, Mr. Z. Chaudhary, learned counsel for the petitioner. So Chaudhary submits that he may be permitted to file amended cause title with pair portion of the petition. Pair allow, recessal is the matter. After 1 week.
And be published.
Item for order. Item number 6.
None appears for the parties on call. It appears that on 17/3/2026 also the parties remain absent, remain unrepresented. Remain unrepresented, and today also they remain unrepresented. In view of above, this RSA 2028 of 2005 stands dismissed for non-prosecution. Recessal return the record of the learned trial court and also of the first appellate court.
Number 7.
Lord, as per office completed 27/3/2026, the substitution petition has not been typed, your lordship, but they have filed a substitution petition. It's not on record.
You are for the respondent.
Respondent.
None appears for the appellant on call. However, miss, your name please?
J. Sharma.
J. Sharma, learned counsel for the respondent present. Referring to the office note dated 27/3/2026, learned counsel for the respondent submits that the appellant has not yet filed a substitution petition, but as per her information, the appellant has already filed a substitution petition, but the same has not been placed on record. Accordingly, it is provided that recessal is the matter after a week. Taking the implement petition filed by the appellant hearing. List accordingly.
Item number 8.
May it please your lordship. Notices has been issued to respondent number 5-1 to 5-3.
Heard Miss
S. Azmi.
S. Asmi, learned counsel for the appellant, and Mr.
P. on behalf of PK Decker. For
Doimari, learned counsel
of
appearing
one-
on behalf of Mr. P.K. Decker, learned
respondent 1 to 4 and
counsel
6.
for the respondent number 1 to 4 and 6. Office note dated 27/3/2026 indicates that notice issued to the respondent number 51, 52, and 53 returned with a report. Return answer with a report. Insufficient address returned to sender. You obtain a instruction from the appellant and file appropriate and take a step in the address furnished. Uh, the learned counsel for the appellant is directed to obtain necessary instruction in respect of the address of the respondent number 51, 52, and 53, and to take step upon them within a period of 1 week from today. Recessal list the matter after 4 weeks. Step be taken by speed post and also by usual process. List after 4 weeks.
Obliged.
Item number 9.
Wait, please. The appellant died, my lord. Independent, we have taken steps, my lord. In the last occasion, this honorable court was directed the registry to calculate the delay, my lord. They have the report has come, my lord. Initially, the registry is calculated as 605 days, my lord. Subsequently, it was 165 days, my lord. Report. 65 days, my lord. And delay has been explained, my lord.
Which is the application dealing with the condonation of delay?
It is
I number
2971. I 2971.
in which paragraph it has been explained?
That is, my lord, paragraph 5 and 6, my lord. And from the paragraph 2 also, my lord, the legal representatives came in with the council, my lord. Paragraph 2.
Heard Mr. Chiladitya, learned counsel for the applicant. This application under Section 5 of the Limitation Act is preferred for condonation of delay of 603 days and for setting aside the abatement and substitution of legal heirs of the deceased respondent struck defendant number 1 who suffered demise on 12/5/2023. Mr. Chiladitya, learned counsel for the applicant, submits that the sole appellant, Sri Birendranath Das, suffered demise on 12/5/2023, and the applicant herein made their counsel on the last part of February, and they were not aware of the legal provision and also the names of the legal heirs to be substituted in place of the deceased appellant. And as the right to sue survives against the deceased appellant, and the counsel for the appellant asks the petitioners to collect the names and address of the legal heirs of the deceased appellant and suggest them to file appropriate application before this court. And he also submits that the reason for delay is explained in paragraph number 2, 3, 2, 5, and 6 of the application, and that the delay is not intentional and intentional, rather the same is circumstantial. And in fact, no, and he also submits that in fact, by order dated 16/3/2026, a coordinate bench of this court has directed the registry to calculate the actual delay, and accordingly the registry has filed one office note dated 19/3/2026, which indicates that actual delay is only 165 days. And since the said delay has sufficiently been explained, Mr. Seladityo has contended to allow this application. Having heard the submission of Mr. Seladityo, learned counsel for the applicant, this court has carefully gone to the petition and the documents placed on record and also the explanation put forwarded in paragraph number 2, 5, and 6. And it appears that the delay has sufficiently been explained, and accordingly this interlocutory application stands allowed. Delay of 165 days in preparing the petition, in preparing the substitution petition, stands condoned. In terms of this, IA stands closed. IA number 2973.
7.2 is for setting aside abatement, my lord. And 2973 is the for substitution, my lord.
Part, Mr. Seladityo, learned counsel for the applicant. This application under order 22, Rule 4 of the Code of Civil Procedure is preferred by the applicant for substitution of legal heirs of the deceased respondent. Struck defendant number 1, who suffered demise on 9/5/2021. No, Mr. Seladityo,
Lordship.
in the cause title of this application,
Typographical mistake, my lord. It's from mistake from my side, my lord. In the prayer portion, my lord, it was 12/5/2023, my lord.
no, in somewhere in the petition you have mentioned him as respondent defendant number 1, and somewhere you have mentioned it as appellant.
He was the defendant in the suit, my lord.
Equal to no? Who suffered demise on 12/5/2023. 2023. And in his place, the legal representative The N said defendant number 1 left behind 3 legal heirs, namely Polas Das, Shashanko Das, and Bolu Das, and they are required to be brought on record as the appellant in the RSA number. What is the RSA number?
204, my lord.
204 of 2019.
2019.
And under such circumstances, Mr. Siladitya has contended to allow this application. Having heard the submission of Mr. Siladitya, learned counsel for the applicant, and also having considered the facts and circumstances on the record, this interlocutory application stands allowed. The legal heirs of the defendant number 1, namely Polas Das, Shashankar Das, and Bolu Das, they implemented in the RSN number 204 of 2019. As the appellants. In view of the order passing the IA number 2973 of 2024, Mr. Siladitya, learned counsel for the petitioner, applicant shall file amended cause title in the RSN number 204 of 2019 within a period of 1 week from today. IA number 2972. Heard Mr. Siladitya, learned counsel for the applicant. This application under order 22 rule 9 within bracket 2 of the Code of Civil Procedure is preferred by the applicant for setting aside abatement against the sole appellant who suffered demise on 12/5/2023. Mr. Siladitya, learned counsel for the applicant, submits that the appellant in RSA number 204 of 2019 suffered demise on 12/5/2023 and on account of the death of the sole appellant, the RSA number 204 of 2019 stands abated, and that the legal heirs of the sole appellant have preferred an application for implement of the legal heirs of the sole appellant and also for condonation of delay in filing the application and also the present application for setting aside the abatement. And since the delay has been condoned and also the application for implement of the legal heirs have been allowed, the abatement is required to be set aside. And accordingly, he has contended to allow this application. Having heard the submission of Mr. Siladitya, learned counsel for the applicant, this court has carefully gone to the petition and the documents placed on the record. And taking note of the submission of Mr. Siladitya and also considering the facts and circumstances on the record, this interlocutory application stands allowed. And the abatement of the RSN number 204 of 2019 stands set aside. In terms of our base, IA stands allowed.
Deeply obliged.
Document number 10.
May I pay your lordship? Some minor corrections on there in your lordship's order, lordship. Lordship, in paragraph number 2, lordship, I have written. The petitioner was in service from 2010 to 2022. But in your lordship's order, it came on 2010 to 2020. And secondly, Lordship, in paragraph number 3 of the order, in line number 6, or therefore the service of the petitioner was regularized by OM dated 3/3/16, but he was not regularized, Lordship. There was a typographical error on my part.
So a line has to be deleted.
Lordship?
A line has to be deleted from the order.
Yes, sir.
This paragraph number 3 of your
Hmm.
application.
Yes, Lordship.
In which paragraph of the impugn order? Oh, sorry, this order.
Lordship, in para 3, Lordship.
Which part?
Lordship, in sixth line, Lordship.
Pardon?
Therefore, the service of the petitioner was regularized by OM dated 3/3/16, Lordship. Was not regularized, Lordship. That's why I want to delete it. And in paragraph 6 also, Lordship, it is there.
In paragraph number 6, which part?
Last part, first part, Lordship. The basic fact of this case is not in dispute. The petitioner appointed a science teacher in Borthal, Dolaigaon, HS School, and his service, that's that part, Lordship. In his service were regularized by OM dated 3/3/2016. Only that part. Lordship. These two lines.
Actually, as per that OM, your service was not regular.
Not regularized, Lordship.
Then we may insert the word not.
Not, no, yes, Lordship.
Then it will serve the purpose.
We have served the purpose, Lordship. It will serve the
Okay.
purpose.
Okay.
And his service was from 2010 to 2022, Lordship. That I have also mentioned. And here it's 2010 to 2020.
Any other part of
No,
the
no,
order?
only these two parts. Only.
Paragraph number 3 and paragraph number 6.
Okay. Was not maybe inserted also. And 2010 to 2022 it should have been.
And in fact, when his service was regularized,
Was it?
when his service was regularized,
His service was regularized when he was appointed as 25/2/22, let's say.
okay,
Sorry, 25/5/22, let's say.
okay. Heard Mr. Soliha, learned counsel for the applicant. This interlocutory application is prepared by the applicant for correction of typographical error in the order dated 8/9/2025, passed in WPC number 4894 of 2025. Mr. Soliha, learned counsel for the applicant, referring to order dated 8/9/2025, passed in WPC number 4894 of 2025, especially to paragraph number 3 and 6, submits that in the paragraph number 3, it has been observed that thereafter, with an inverted comma, the service of the petitioner was regularized by OM dated 3/3/2016. And also, in the paragraph number 6, it has been observed that the petitioner was appointed as science teacher in Bortal, Dolaigaon Higher Secondary School, and his service was regularized by OM dated 3/3/2016. And he submits that in fact his service was not regularized under the aforementioned OM. And as such, in the line in the 6th line of the paragraph number 3 and in the 2nd line of the paragraph number 6, a word no, the word not be inserted before the word regularized. Before the word regularized. And as such, he is contented to allow this application. But having heard the submission of Mr. Solia, learned counsel for the applicant, this court has carefully gone through the application and the documents placed on record and also perused the order dated 8/9/2025 passed in WPC number 4894 of 2025. Then taking note of the submission of Mr. Solia, learned counsel for the applicant, and also considering the facts and circumstances on the record, it is provided that in the 6th line of the paragraph number 3, word not be inserted before the word regularize, and in paragraph in line number 2 of the paragraph number 6, also the word not be inserted before the word regularize. Regularize. And in terms of above this interlocutory application instance disposed of, the order passed today shall be read along with the order dated 8/9/2025 henceforth for all parties.
Obliged, Lordship.
Item 11.
May it please, doctor, this I is for my lord, a violation of an interim order, my lord. In the meantime, they have filed their objection, my lord. So may I pray, my lord, the main appeal, my lord, it is already fixed for hearing, my lord. Both this I and the appeal should be heard together, my lord, in the hearing, my lord.
Okay. When the appeal is fixed for hearing,
It's already been fixed, my lord, for hearing, my lord.
Date is not fixed.
Date was not fixed, my lord. Your lordship may fix a date, my lord, after Bihu
It
vacation.
was in the final stages of hearing. Or date will be fixed so that the matter can be received.
heard Mr. Siladitya, learned counsel for the applicant, and Mr.
If we are,
learned counsel for the respondent. Mr. Siladitya submits that this interlocutory application is deferred for violation of the injunction order.
Injunction order, yes, sir.
Violation of the injunction order, and that the RSA number 68 of 2012 has already been fixed for hearing, and accordingly this interlocutory application may also be heard along with the RSA number 68 of 2014 on a date on suggested date.
After Bihu vacation, lordship,
The month of May.
May,
14.
the date
14.
14 May. Lordship.
Item number 12.
May it please your lordship, this is an application for correction of the order dated 16/12/2025 in WPC number 3188 of 2025. there is clerical mistake in this order at para 3.1 at the 11th line. Compassionate appointment to a grade 4 post, it should be grade 3 post. Accordingly, DLC in its meeting held on 31/7/2023 had recommended the name of the petitioner for compassionate appointment to a grade 4 post. It should be grade 3 post. I have mentioned in para 3, para 2.
Pardon me, see your name, please?
Lordship, I can see. Number, page 6, Lordship.
Yes.
Object matter that 1, 2, 3, 4, 6, 7, 8, 9, 10. 11 line, Lordship, from the top, Lordship. DLC. Lordship got it. Page 6, page
Yes.
6, Lordship. Top 11 line, Lordship.
Yes.
DLC in its meeting dated so and so recommended the name of the petitioner for compassionate appointment to a grade 4 and Lordship.
Hmm.
There will in the petition they have stated it is a grade 4. So how can Lordship can be sent it he can be appointed in a grade 3 Lordship?
Grade 4 post chalo.
No, Mr.
But in the
Henry,
office memorandum dated 18 September 2024, I have not annexed it. In this office memorandum, it compassionate appointment is grade 3 post. Lordship, I can park it.
Mr. Henrik,
Lordship.
in the office memorandum, it is mentioned as grade 3 post.
They are mistake Lordship done in the petition they have stated the grade 4 post there.
Have you gone through the repetition
Lordship, I have the petition.
copy?
Lordship.
There it has been mentioned.
Lordship.
There it has been mentioned as grade 4 post
Grade 4 Lordship, they have stated in paragraph number 5 Lordship.
in the repetition.
In the petition. That's what I have my lord read up on paragraph number 11 Lordship, page number 6. Paragraph 5 of page 6 Lordship, no petition Lordship.
The repetition is not enclosed herein.
Not include.
And even in the synopsis also they have been stated grade 4. In the synopsis, they have mentioned that color grade 4.
And in the repetition, paragraph number?
Paragraph number 5 Lordship.
Paragraph number 5.
The relevant portion is paragraph page 6 Lordship, 11 top 11 line. DLC in its meeting dated 31/7/2023 Lordship. Their name is name has been his name has been recommended for the for the corporation appointment for the grade 4 post.
Hmm.
Until and unless they have amended that.
Rate petition.
Lordship, it is difficult, Lordship.
They have to amend the rate petition.
Lordship, that paragraph, particularly that portion, that paragraph number 6.
Yes,
I have to amend, my lord, this petition.
this application.
Cannot transmit that order developed. Because they have already been
No,
stated.
unless the rate petition is amended, this order cannot be,
Lordship.
correction may not, cannot be done in the order. In the rate petition, you have mentioned it as grade 4 post.
Yes.
So all over, my lord, they have mentioned the gate 4 post, my lord. In that DLC thing,
Hmm.
in our, my lord, in the annexure, Lordship, it is not clear. Paragraph of page 37 is not clear. Well, and I.
So, madam, it is better to withdraw this application.
Lordship, better to file a fresh, Lordship.
Yes. Or miss, your name please,
Bidas.
learned counsel for the applicant. This interlocutory application is preferred by the applicant.
My lord, I have to file amended writ petition.
To amend the rate petition.
I amend the writ petition.
For correction of the order passed by this court on 16/12/2025 in WPC number 3188 of 2025. However, the learned counsel for the applicant submits that she may be allowed to withdraw this application with a liberty to file a fresh application to amend the WPC number 3188 of 2025. Accordingly, this interlocutory application stands disposed upon withdrawal. However, liberty will remain with the applicant to approach this court again by filing appropriate application.
Number 13.
Right.
Definitely, dear Lord. Lordship praying for 4 days delay, my lord. Only 4 days delay.
Heard, miss,
L Wajida, my lord.
learned counsel for the applicant. This application is preferred under section 5 of the Limitation Act 1963 for condonation of delay of 4 days in preferring the revision petition. Issue notice to the respondents, struck opposite parties, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Oblige, your lordship.
Number 34.
My official lordship. Lordship, here in this matter, lordship, as per the last lodging order, your lordship. Directed to take steps upon that respondent number 5, 8, and 15, your lordship. We have taken, your lordship. 5 is complete, and 8 and 15 are returned to be not served, your lordship, isn't it? Thirty-four. And
Heard, mister, your name, please?
T Gogoi, your lordship.
Learned counsel for the appellant.
Lordship.
Office note dated 12/11/2025 indicates that though the appellant was granted 7 days time as final opportunity to take fresh step of service of notice upon the respondent number 5, 8, and 15. Yet, the appellant has failed to comply with the said direction. The office number, the order of lodging by court dated 12/11/2025. What to do?
Lordship, I may with take instruction, lordship. So, time
The
may be
learned
granted.
counsel for the appellant submits that he may be granted some time to obtain instruction. Parallel, recessal is the method on. Fix it.
And lordship, in the regarding respondent number 1, your lordship, the council for the 1, 2, 3, and 4, they submitted that here respondent number 1 has been expired, your lordship. Till that they have not submitted regarding details of their legal heirs, your lordship.
Who is the counsel?
On the last occasion, appear name has been not reflected, your lordship. Jet Mukit, lordship. Probably name is sorry in the place, lordship. In the last order is reflected, your lordship. Last order that 2,
So
3.
there was a direction to take a step for filing application for
Lordship,
substitution.
lordship.
Where is that application?
No, lordship, they have not submitted that legal heirs details, your lordship. So you could not file that substitution petition, your lordship.
The learned counsel for the appellant also submits. Also referring to the order dated 2/3/2026 submits that
2, 3, lordship.
the appellant was directed to file application for substitution of respondent number 1 who suffered demise on 23rd of July 2024, but no such step could be taken as the address of the legal heirs of the respondent number 1 has not been furnished by conducting counsel for the respondent. However, the respondents remain unrepresented today, and in view of above, it is provided that recessal is the matter after a week.
Lordship.
Fix it. Fix it.
21st September.
Lordship. Alia.
May the case is your lordship. Your lordship, sorry for interruption, your lordship. Your lordship, while the method is called for item number 10, pertaining to other column, your lordship. I was on legs, your lordship. So kindly my presence may record it wherein I has allowed your lordship correction of names, your lordship. I am appearing for respondent secondary education.
Ms. P. Das or learned standing counsel for the respondent in secondary education.
And be placed.
Items for admission, item number 2.
May I please, your lordship? My
Yes.
lord, here in this case, my lord, the present respondent was filed the title suit before the landed court below on 2014, my lord. Thereafter, the petitioner appeared before the court and filed their written statement. Thereafter, my lord, due to COVID and communication gap with the landed council, they could not contact with the advocates. Therefore, several order was passed. And finally, my lord, on 27/9/2022, order was passed in favor of the plaintiff, the present respondent. Lord, the petitioner was unaware about the said judgment and was was not any information about the case, my lord. In the meantime, after 1 year, the plaintiff filed the title execution, my lord. In the title execution, the petitioner also the petitioner was unpresent several dates, my lord. And thereafter, the execution order was passed in favor of the plaintiff. And thereafter, order was sent to the additional deputy commissioner. And deputy commissioner sent the order was to the circle officer, and circle officer making the partition in favor of the plaintiff by making new dag and patra. Thereafter, the delivery of possession what we have given in favor of the plaintiff, and thereafter the petitioner came to know about the execution order. Well, thereafter they came to the High Court for file CRP, because, my lord, there was 3 years delay to file the appeal, my lord, with condonation of delay. In condonation of delay, the time may be more time may be taken. In the meantime, execution may be done in favor of the plaintiff, my lord. Therefore, they filed the CRP, and this honorable court was pleased to pass the interim order by staying the operation of the title execution, my lord. As per information, my lord, the petitioner already filed the title appeal with condonation of delay, my lord. Therefore, the case stay order may be vacated, my lord, by given any opportunity or any direction to the petitioner to contest the case, my lord. To contest the case in lower court, my lord. I have no any objection to vacating the stay order, my lord, because they already filed the title appeal with condonation of delay. My lord, there may be taken
in the
some.
revision petition, you are not challenging any order. But you are praying for setting aside the execution case.
Execution, my lord.
How this civil revision petition is maintainable?
Well, civil division petition may file in
May file.
under Article 2 to 7, my lord.
No. To demonstrate, no, to invoke the jurisdiction of this court under Article 226, 227, you have to demonstrate that while conducting the proceeding of that title execution case, the learned executing court has committed some mistake. Hmm?
Nothing such procedure. What my brother said in earlier also, they have contested the title suit up to the level of DW. They failed to adduce evidence, arguments are out, judgment was passed. They have not challenged the decree.
That admitted. I have already said.
They have come up with this staying of the execution law without impugning any order.
Well, in execution case, notice was received by the respondent number 1. Respondent number 2 already died.
No,
Respondent number 1.
against the judgment and decree, you
was-
could have preferred appeal.
Yes, my lord. Ought to have filed the appeal, but there was delay. Therefore, they come to the court for protection in the title execution.
You say
The execution may be done.
better you withdraw this petition, otherwise we will dismiss it with heavy cost. This is abuse of the process of the court. You think it over, we will take it up after 5 minutes.
Numbers 4 and 5.
This is a condonation application, my lord. There's a delay of 218 days in preferring the review, my lord.
So you were pressing who is IA now?
I
For
3036.
3036. This I is for condonation of delay.
Condonation of delay. My lord, the delay essentially happened because, my lord, what had happened here, my lord, we were arrayed as defendants number 1, 2, and 3, and the plaintiff had sought declaration of title, etc. My lord. Suit was decreed, my lord. Eventually, the other defendants preferred an appeal, my lord, which came up before your lordship for consideration. In that appeal, my lord, we were not made parties, my lord. Subsequently, however, my lord, they filed an application for impleadment of the defendants who were left out, including our name was sought to be impleaded, my lord. But that IA, for some reason, was not pressed, and the judgment was delivered, my lord. Now, since that judgment partly went against our interest, also we preferred a SLP before the Honorable Supreme Court, my lord. When this aspect of the matter was pointed out, the Honorable Apex Court said that it'll be better if we move a review first, and in case we are unsuccessful, then we can come back in an SLP. Now that order of the SLPs with the review, I'm providing a copy. So that's my only.
So when the SLP was dismissed,
SLP was disposed of on 25/7/2025.
and since then there is delay of 200 and
No, my lord.
when?
My lord, we filed it on 8/9/25. Majority of the period, my lord, if I may just give the dates, my lord. To 2012-2024, my lord, the judgment was delivered.
Judgment was delivered on.
Can I also give the relevant dates regarding that
Yes,
impleadment? 2/12/2019, my lord, they first sought impleadment. My impleadment, my lord.
Yes.
Then, my lord, 14/2/2020, my lord, dusty service was ordered to be effected on us. My lord.
So service effected upon you.
Yes.
Yes.
24/2/2020, my lord. We entered appearance, my lord.
Yes.
If I may just clarify here, my lord, though we appeared, my lord, there was no order by then impleading us. We were just merely notices were issued in the IA for impleadment. Then on 2012-2024, my lord, the IA for impleadment was not pressed, my lord. On that very day, my lord, that is 2012-2024, the main connected RFA was also disposed of.
Yes.
Then 1/4/2025, my lord, that's my statement. That is when I came, since I was not formally impleaded, I did not learn about the judgment, and it is only on 1/4/2025 that I derived knowledge of the judgment from the council. Then, my lord, then, my lord, 24/4/2025, we moved the Honorable Apex Court by filing the SLP.
Thereafter,
25/7/2025, my lord. The SLP was disposed of, giving liberty to prefer review, my lord. 8/9/2025, my lord, the IA along with the review was filed. So, my lord, our ground is very limited, my lord. We are saying, my lord, since we were never formally impleaded, my lord, we lost out on a chance to present our case, my lord. Of course, in your lordship judgment, your lordship held that there could not have been a declaration of title in so far as we are concerned, because we were merely defendants and we did not lodge any claim of title, etc., my lord. Now, my lord, since so far as the delay is concerned, my lord, that we are attributing to the fact that we had to, since the judgment was already delivered, the time was consumed in pursuing the SLP, my lord. After that SLP was closed, we had to again, my lord, get the review, etc., drafted, contact with the lawyer from Delhi, and that is how the review was filed. My lord, I must point out, my lord, they filed an affidavit, long affidavit alleging suppression, etc. That we've misled the Supreme Court. We are also misleading this High Court, my lord. I'll just clarify. I'll reply to however they respond, my lord. I'll just clarify that first of all, we have not. We have clearly stated in our application that yes, notices were issued to us. We've also mentioned categorically that yes, we had entered appearance during the RFA proceedings, but the ground remains that we were never formally impleaded. In fact, even in the judgment, your lordship will find we were perhaps not heard. Your lordships would know better, my lord. But in the judgment also, my lord, we are not shown as represented because IA, which was filed for impleadment, was eventually not pressed, my lord. But insofar as the delay is concerned, my lord, these issues
you have received notice.
Correct.
You have entered appearance.
Yes. Yes.
Then,
yes, my lord. True, my lord.
and you have participated also.
Yes. According to me, my lord, that of course is a subject matter of the review, my lord. There I will show, my lord, how this could not have been done because it was their appeal, and under Order 41 Rule 20, my lord, it was mandatory upon them to make me parties, my lord. Then comes the other part, my lord. If your lordships would have passed an order under sub rule 2 of Rule 20, my lord, then probably I could have been accommodated. But unless that prayer for impleadment comes within 30 days, my lord, the appeal had to be dismissed. So that discretion was never, perhaps it was never brought to the notice of this honorable court that the impleadment was still awaited in respect of the co-defendants, my lord. Because there is no formal order, and the only order your lordship finds in the IA is that it has not been pressed, my lord.
No, that appeal was heard over a period of time.
Yes. Probably, my lord.
For
Probably.
many days.
Probably, my lord. I'm not aware, my lord. Probably it may have been heard on a number of occasions, my lord. But the only question was that these respondents, these not even respondents, my lord, these applicant defendants were never impleaded in the cost title, my lord. And that is precisely why the Supreme Court said that if that is your ground, then you should better approach the High Court in a review. Because
Yes, Mr. Sodure, in respect of delay, do you have any objection?
No, you're not trying to point up your lordship. So see,
fraud was committed, your lordship.
No. Fraud we will see in the main petition,
If your lordship,
review petition.
if your lordship will see the.
No, only this IA.
No, I.
Today we are only in this IA.
Because if your lordship will see. Here. If your lordship will see here, page 63, if your lordship see, my reply.
Yes.
Your lordship names are here, your lordship will see. Advocate A.R. Borbe appearing for Sri Pulin and 5 others. 5 others include these 3 persons, your lordship. So when they have appeared, they have been implemented, they have filed Okala, where is the question of they are not being parties? They have contested the matter, your lordship, by through advocate, your lordship. Now they are saying they are not parties. Okay, their Okala is also on record. The Supreme Court, they didn't say that we filed, the Supreme Court.
No, Mr. Saurari, that argument we will consider in the review petition.
But delay, how can the delay be condoned, your lordship?
No,
Because-
delay.
Because your lordship saying if there is suppression of fact, then this delay cannot be condoned, your lordship.
Hmm.
The judgment to the effects court, judgments are there, your lordship.
Okay, produce it, we will see.
We'll give them that. Your lordship say.
Citation.
2005. Oh, it's 60.
Which paragraph you are relying
Your
upon?
lordship. Para 21.
Para?
21.
21.
21.
No, here Supreme Court has not dealt with the issue of condonation of delay.
Yes, no, your lordship says, your lordship says discretionary power.
Hmm.
Discretion, if your lordship see. That
So,
discretion-
whether they have suppressed the material fact
Yeah,
or not,
that is-
that has to be examined in the review petition, not in this interlocutory application.
Your lordship will see, because what I'm saying, your lordship.
Hmm.
They have filed a Okala number in I put. What are, because they are relying on that order to close, because on the day when they have been represented by the advocates, that's why this application was closed. Because they have filed their Okala number also, page 59, if you look at the Okala number, there.
Hmm.
Page 59. How can they say they were not aware of it? Page 59. Annexure R7.
Hmm.
So when we get all these people are fine. Okala number.
Hmm.
So if they have filed Okala, review the procedure, they have participated in the proceeding. This technically, they have.
No, Mr. Soduri, you see, in this interlocutory application for condonation of delay,
Yes.
we will only examine whether the ground assigned for the delay is sufficient or not.
Then your lordship see, have to see also whether your lordship will exercise a discretion where there is a suppression of facts.
Hmm.
Suppression of facts are
No,
there.
no. Here
Because
the
in the
application
apex
of,
court, they have made wrong statement before the apex court that they are not parties. They have said they are not parties and and it has been heard without
no,
hearing.
that's all right.
They have been represented by advocate. That is a false
No,
statement.
no.
Your Lordship.
We will appreciate your submission in
Yes.
the review petition, not in this application.
But your Lordship, whether this delay can be confirmed, that's the issue.
Yes, or whether their explanation is sufficient or
No,
not.
explanation let us say in the application, Your Lordship.
Hmm.
Conversion delay application, let us see that.
Hmm.
Your Lordship, I take it, para two, I just read that para, Your Lordship. That the honorable, that is honorable past judgment and order received in RFL. Though the applicant was proper and necessary, you are not implicit the party. It has said RFL. Your Lordship, what has happened? In IA, they filed the in IA. The IA is part of the main matter. Your Lordship. They cannot say that I have filed the IA, I have not participated in the RFL. They cannot say that. What they are trying to truncate the IA with the RFA, Your Lordship. Because what they are saying, we have filed IA, it is equivalent see, present file an IA for implementation. So why IA have implemented? The court has implemented it. That's why the Okanagan has been taken on record. Because when the court has issued notice, that they have never stated that we have not been implemented party. When the participants were proceeding before the honorable court, they have not said that we have not been implemented defendant, respondent, sorry. They have not stated, now they can take this plea now. When the hearing was going in length, they have been represented by advocates and extensive argument for several days. And now, and they have not raised this objection that we have not implemented a party, Your Lordship. That objection was not raised when Your Lordship heard the matter. So how can they raise it today? It is an afterthought to you. And it's not sustainable also. How can you, when you have filed a Okanagan, how can you say I have not been implemented? Without, if she is not a party, then how can the Okanagan be taken on record? And they have been represented by advocate, Your Lordship. That today they cannot turn around that some other advocate, no, we didn't appear and someone else, we don't know what has happened. If my learned friend doesn't know what happened in the proceeding, he should not say all the things. Because the proceeding, I was there, the proceeding, Mr. Goswami was there, the counsel, he argued at length, and he argued represented everyone. That time he didn't say that these people have not been implemented. It is on the direction of the court I have filed this application, Your Lordship. And I should note that they have received notice, they have, suppose if they don't appear.
Mr. Fuluri,
Yes,
you
sir.
are again on the merit of the review petition.
No,
We are not in the
I'm not-
merit of the review
No,
petition now.
because their concept is, they have the concept which is developed that they have not been made, so the delay has to be condoned. That is what they are trying to, they are trying in a different way. They are trying to reput the review petition. It is the question that when they file the review petition is important. Question is not, Your Lordship, how they, because when they have taken rely on the representative, we have not made point. If it is so, I am sure they have been made a party. So question of delay, consideration doesn't come at all. If that is so, Your Lordship, either they should not say that this has happened. We have not filed Okanagan. They should say, had they not filed Okanagan, he would have been justified. They have filed Okanagan. They entered, now they cannot turn around. We are not made parties on this thing. How can this please be taken up at this stage? In the apex court, they have made this statement that we have not been made a party. How can it be that? When court has issued notice has been served on, and suppose let me take an example here. Suppose notice has been, suppose people don't appear, it goes ex parte. Can they come and say, no, it has been heard ex parte, we are not bound with it? Can they say that? It is there, they have received notice, it is their option to appear or not appear. Once they have filed Okanagan, they have to appear, engage counsel and appear. They don't engage counsel, just if I am not implemented party, they don't engage counsel to appear in the matter also.
No, that's all right. We are not on that.
The question is, then the question of days will come. How can they select the dates? The question they are taking a sweep from the application to here. That they cannot do. There their problem arises, Your Lordship. They are trying to circumvent the delay portion by something else. That they cannot do, Your Lordship.
No, that cannot be.
Yes, Your
But
Lordship.
now we are concerned only with the explanation.
Yes, that-
They
that-
have put forwarded
That explanation.
for the delay.
No, that explanation cannot be taken on record because the fact that this is not a correct fact.
Hmm.
What they said is not a correct fact. How can you go for a
No,
conditional?
no, only in respect of delay.
Yes, you are, because delay, how will you, how will you not able?
Mr. Soduri, you say,
Yes, sir.
after the judgment
Yes,
of
sir.
this court, they have approached the Supreme Court.
Yes, sir.
Supreme Court has directed them to approach
But
this court
Supreme Court,
by
you
filing
see the
review
Supreme
petition.
Court order, Supreme Court order, if you not should see.
Hmm.
Yes, what they have said is that. What Supreme Court order, just give me a minute, okay? The Supreme Court. Yes, sir. Excellent. Election. Yes, sir. 27. If you not see page 26, so page 26 down, Supreme Court order.
Yes.
After arguing a substantial land, London Council for the petition seek permission to withdraw the special leave permission is granted. The special leave petition stand dismissed as withdrawn.
Hmm.
Dismissed. Dismissed as withdrawn with liberty the petitioner, within bracket, who claims himself to be defendant number 3 in the suit and who alleges that he alleges he was anyway not alleged as respondent in the RFA so and so to apply before the High Court for a review of the judgment and decision. It is very clear, you are not to visit the order. You are not saying what they have said. If he is not a party, then only they are not. What he is trying to distinguish between the RFA and this thing. If you are not say, he has referred to RFA 82. IA, he has filed the Wakalam in IA. He said, I have filed the Wakalam in IA only. So if he filed the IA is a part of the RFA, because of truncated, what they are very cleverly distinguished the two facts that RFA we have not made here. So that cannot happen here. So where is the question of making the they are making a statement that they have not made.
No. You are again repeating the same thing.
Yes, sir.
You tell me whether according to you, the explanation put forwarded by them for delay in filing the review petition is sufficient or not?
Sufficient.
Not sufficient.
Not sufficient.
Okay.
That is not sufficient. Because in terms of the
Okay.
judgment of the effects for another judgment, everything really has to explain your lordship. Delay has to explain
That's all right. Delay has to be explained.
explain your lordship. But here there is not an explanation at all. They cannot say that we have appeared, after that we didn't appear that we are not bound by the order.
Okay.
They cannot say that.
Okay, I will examine the matter. Heard Mr. Deka, learned counsel for the applicant. Mr. P. Choruri, learned counsel for the opposite party. Order reserved.
Should I just clarify on that? My lord, I have made that statement categorically that I entered appearance. So there is absolutely no suppression. Secondly, my lord, I
No,
still stand.
again, you are doing same thing.
My lord.
You will examine in the review petition, not here.
Yes, very.
Provided we allow the,
Condemnation.
yes,
Yeah, lordship.
otherwise not. Okay, you
Yes,
submit it to court person. Another IA was filed.
That we have filed Wakalam only yesterday.
Okay.
What happened, your lordship? One is taking help of the other. He's after this, he has filed his review also. His SLP was dismissed. His SLP was dismissed with effects of your lordship. Thereafter, he filed it in 2026, your lordship. SLP was dismissed way back, your lordship.
SLP was dismissed. Thereafter, we have filed one.
Yes, Mr. Upaide, this IA is filed by you
Yes,
for condonation of delay.
condonation of delay.
Here, notice was issued.
Notice was issued.
Perhaps
Mr.
they will
Chaudhary,
find
you
out
are
this.
appearing in this IO.
I find out. Yes,
You have filed.
yes, find out.
You want to,
I'll reply to that.
you want to file a reply.
I'll reply to that, because I have
Okay.
to expose everything here.
Okay. Heard Mr. Upadhyay, learned counsel for the applicant. And Mr. P. Chaudhary, learned counsel for the opposite party. Mr. Chaudhary submits that he has filed Wakalatnama in this matter and he will file
Our
his
name is not
response.
reflected. Our name is not reflected.
Okay. Response in this application. And he also submits that his name has not been reflected in the cause list. List is directed to do the needful in this regard. List the matter after. Chaudhary,
Your Lordship, can you have it on 19th of May? 19th May,
19 will be too long.
I won't be there. I just say April is come only. We'll have to file the reply also. That will
9th of April or no, 9th of May or 19th of May.
19th of
19th. Okay.
May.
May I Lordship? My lord, I have no objection to withdraw the matter, but I have little submission to clear myself. My lord. My lord,
What submission?
my lord, as per civil division petition can be filed under Article 227 of the Constitution of India against an execution order, but only under limited circumstances. It is
Which
not
order you were challenging in the civil revision petition? Which order passed in the execution proceeding you have challenged here?
my lord, the only thing, my lord, if there is any grave injustice is there,
Only
grave injustice or
grave injustice.
then the High Court may exercise the power, jurisdictional power.
What grave injustice?
If any grave injustice done by any
No,
judicial court,
you tell me what is the injustice done to you?
my lord, they purchase 10 acres of land from respondent number 1 and 2. My lord, from two separate boundaries, my lord. Same dak and same patta.
No, first you tell me whether by exercising the jurisdiction under Article 227, this court can set aside that proceeding, execution proceeding? No. Then how this civil revision petition is maintainable? How?
I may be allowed to. Dismission withdrawal.
Heard, Mr.
Ziu Ahmed.
Learned counsel for the petitioner, and Mr. Puddar, learned counsel for the respondent.
1 and 2.
Respondent number 1 and 2. The learned counsel for the petitioner submits that he may be permitted to withdraw this petition as one regular second appeal. What is the number?
Not regular, first appeal has been filed.
First
appeal.
appeal has been filed.
What is the number?
Number I have not collected.
They have filed on this case for condemnation of.
Condemnation appeal.
20.
They have already preferred one one
Regular.
regular first appeal and
Along with a petition for condemnation.
along with a petition for condemnation of delay, and the said proceedings are pending before the court of
Civil Judge Senior Division Barpeta.
Civil Judge Senior Division Barpeta. And accordingly he contended to allow him to withdraw this civil revision petition. Taking note of the submission of learned counsel for the petitioner, he is granted. No, he is permitted to withdraw this petition. However, subject to payment of a cost of rupees 1,000, which shall be deposited before the Secretary, District Legal Service Authority, Barpeta, within a period of 1 week from today. The cost is imposed as this revision petition is preferred when the provision for appeal is available, and without exhausting the same, he has filed this petition, and it appears to be an abuse of the process of the court.
apply this.
Item number 30.
In view of the order passed in the CRP numbers also, I numbers also stands closed. এই আগৰ হেৰিটো ৰিজাৰ্ভ কৰাটো
Before my learned can start, may I say that this matter may kindly be taken up day after tomorrow or Monday, possibly.
on
Tomorrow, day after tomorrow or Monday, contribute to this court.
day after tomorrow or Monday. Yes,
No, this.
heard Mr.
A Burua.
Learned counsel for the petitioner and Mr. Soudary for respondent number
Respond number 1 and 2, madam.
1,
1 and 2, madam.
1 and 2. Mr. Gogoi for 4 and 5. Mr. Soudary, press for listing the matter day after tomorrow. Pair allowed. Press and list the matter accordingly.
Item 31.
May I please, Your Lordship?
Yes,
Lordship, in the suit, I am the defendants and the respondents is the plaintiff. Plaintiff filed a suit for their declaration of their tenancy right and for permanent injunction. And that suit has been pending. In that case, Lordship, we have filed a written statement and counterclaim. And on basis of a reply notice that has been sent by them to me during pendency of the suit. On that reply notice, Lordship may kindly come, reply notice dated 18/3/2022, page 66. Lordship.
page number
66. 66. Lordship may kindly peruse the last para, because we have sent a legal notice to them to vacate the suit premises. I am the landlord of the premises. Against that, they have filed a reply notice. And that has been admitted by them in the WS of my counterclaim. And the aforesaid paragraph that as regard to the
no.
statement,
You come to the impugn order.
if impugn order is, there are two orders. Actually, we have filed a petition under section 9 and read with section 14(1).
No, that's all right. You show me the order.
Lordship may kindly peruse on page 96, Lordship. There are two orders. One order is the framing of the preliminary issue and other was the rejection. Order dated 3/5/2024, page 96, Lordship. Both the parties may read it, Lordship. Both the sides are represented. Plaintiff has filed the cost of rupees so-and-so today. Let the same be deposited in DLSA in Sugia. By this order, petition number so-and-so will be disposed of. In the said petition has been filed by the defendants under section that has been filed by me. Under section 9, reduce order 41, rule 1 CPC. It is prayed that a preliminary issue on the law point be framed, decided, and thereafter pass necessary orders for dismissing the suit of the plaintiff with cause. It is stated in the said petition that as per the plaint and the documents filed by the plaintiff himself denied the tenancy under the defendants. It has been submitted that the plaintiff has instituted the suit on 21/5/2019 and the verbal agreement for sale purchase has been entered into between him and the defendants in June 2019. And that after the institution of the instant suit, the plaintiff is no longer a tenant under the defendants. It is also contended that the plaintiff has instituted the suit for declaration of his tenancy rights in respect of the suit premises. And when the plaintiff himself denied the tenancy, the cause of action for the instant suit has been ceased to have existed, and as such, this court has no jurisdiction to try the plaintiff's suit, and as such, the suit being A, not maintainable in the law under provision of the section 34 of the Specific Relief Act 1963. B, not tenable in law for want of jurisdiction of the learned court. C, bad for want of cause of action. It is required to frame preliminary issue on law points as mentioned aforesaid in A, B, C, and to decide the issue at the first instance to prevent abuse of the court as well as to administer justice. In the case record heard, both sides learned counsel for the plaintiff did not submit any written objection. However, he submitted his objection verbally. The learned counsel for the plaintiff has submitted that they have admitted the tenancy, and there can be no question of framing preliminary issue on maintainability of the suit. For want of jurisdiction of this court as well as for want of cause of action, the learned counsel further submitted that The instant petition is not maintainable and the defendant has filed this petition in order to delay the matter, as nothing in the plain contents the plaintiff is not the tenant of the defendants. The learned counsel of the defendants, on the other hand, has reiterated the contents of the petition and has referred to the reliefs claimed by the plaintiffs in their plain, being relief number Roman 1 and Roman 2, as well as para number 24 of the written statement filed by the plaintiff against the counterclaim of the defendants. The learned counsel has also referred to the legal notice sent by Ms. Niva Kolita, advocate, as well as the reply of the plaintiff through his lawyer, Sri Syam Nath Tati, wherein it was mentioned that the plaintiff has agreed to purchase the suit land measuring 2/10 lakhs for total consideration of rupees 20 lakhs, out of which plaintiff has paid the defendants rupees 2 lakhs, and submitted that the fact of payment of rupees 2 lakhs out of the total consideration of rupees 20 lakhs, this entitles the plaintiff to claim in relief as a tenant in the suit, and therefore the aforesaid issues need to be framed and decided. Lordship, in the legal reply notice, they have admitted that they are no longer a tenant under the defendants, because I have allegedly executed an agreement for sale of land with them. Perusal of the case record reveals that the plaintiff has contended in his plain that he is the tenant of the defendants and that he has regularly paid rent to the defendants, and that as the defendant number 1 and 3 refused to receive the rent for the plaintiff, as such the plaintiff started depositing the same in the learned court of Munsif number cum rent controller Tinsukia as per law. Further, perusal also reveals that it is contended by the plaintiff that defendant number 1 in the year 2015 proposed the plaintiff to sell the suit premises along with the entire plot of land, and the final consideration was fixed at rupees 20 lakhs. Perusal of the case record also reveals that the instant case was pending in the stage of HBPH and both the parties have filed their witnesses. Also, it is seen that the court has already framed issues on maintainability and cause of action as issue number 1 and 2 respectively. As such, this court of the considered opinion that issue number 1 and 2 be heard and decided first before deciding the other issues. Along with it, this court also framed an additional issue on the point of jurisdiction, which is as follows: whether this court has jurisdiction to try the instant suit. The additional issues is framed and tagged along with the case record in a separate sheet. Both the parties are directed to appear on next date fixed and advance their submission on issue number 1 and 2 as well as additional issue number 1, fixing 31st May 2024 for hearing evidence on issue number 1 and 2 and additional issue number 1. The date was fixed on 31st May 2024 for hearing on the issues that have been framed, Lordship. And now by the impugned order, Lordship may kindly come to page 100. Or impugned order at 6/7/2024. Both the sides are represented. Today was fixed for order on preliminary issue. Perusal of the case record reveals that the order dated 3/5/2024, this court has framed the preliminary issue on the point of jurisdiction as well as on the point of maintainability of the suit, and whether there is a cause of action in the instant suit, and the matter was fixed for hearing on the said preliminary issue. Sin heard both sides on the point of preliminary issue on the aforesaid point. The learned counsel for the defendant side has stated that the plaintiff at the time of filing the suit was taking steps for depositing rent, but did not take steps till then, and that no documents were filed to show the deposit of rent, and that the plaintiff has no right or interest in the suit land. It is also been submitted that the plaintiff has admitted the notice sent by Srimati Niva Kolita, learned advocate, and from the reply of the learned advocate from the side of the plaintiff, it can be seen that the plaintiff is no longer stated to be a tenant of the defendants, and therefore the instant suit is not maintainable, and this court has no jurisdiction to try a subject matter of the suit, and therefore the plain be rejected under Order 7 Rule 11 CPC, even though a petition under the said section could not be filed earlier. The learned counsel relied on the so-and-so judgment. Lordship, next para 5. On the other hand, the learned counsel for the plaintiff side has stated that the court has jurisdiction to try the suit and there is no cause of action in the instant suit, as the plaintiff has never disputed his tenancy rights in the suit. Order 14 Rule 2 CPC provides that where issues of both law and facts arise in the same suit, and the court is of the opinion that the case or any part thereof may be disposed of on an issue of law only, it may try that issue first if the issue relates to A, the jurisdiction of the court, B, a bar to the suit created by any law for the time being in force, and for that purpose may, if it thinks fit, postpone the settlement of other issues until after that issue has been determined, and may deal with the suit in accordance with the decision on that issue. In the case of so-and-so, it was held by the Honorable Supreme Court that some judgment has been referred by the learned trial court. That's the next para. Now, perusal of the instant case shows that the plaintiff has stated in his plaint that he is the tenant of the defendants and he sought for relief of declaring him as a lawful tenant and cannot be evicted without due process of law, which was denied by the defendants by filing written statement cum counterclaim, wherein they had sought for declaration that the plaintiff is a defaulter in respect of the suit premises and that premises is bona fidely required by them. Now, going to the contents of the document referred by the defendant side, being the reply of the plaintiff to learned advocate Nibha Kolita, the same, in the opinion of this court, would require a careful scrutiny of facts, which is stated in the plain file in the suit, as the plaintiff did not deny their tenancy under the defendants, and the same would be a fact finding inquiry itself. And going by the aforesaid law in hand, it cannot be said that from the bare reading of the plain and the other documents on record, the point of cause of action, jurisdiction, maintainability is a pure question of law, as the same is not apparent therefrom. Considering the above, this court is of the considered opinion that the judgment relied by the learned counsel for the defendants would not apply in the given facts and circumstances, even though it is important. This court had framed the preliminary issue on the basis of the contentions of the defendant. Yet from the submissions of both sides, it appears that the aforesaid question of maintainability, cause of action and jurisdiction in the instant matter cannot be decided at this stage, as the same appears to be a mixed question of law and fact and not a pure question of law. And hence the preliminary issue on whether the court has jurisdiction to try the instant suit or not, whether a suit is maintainable in law, fact, and whether there lies any cause of action in the instant suit has to be decided along with the other issues. In this case, let's say, once preliminary issue is framed by the learned court below, the court is duty bound to decide it. But the learned court below has failed to consider this aspect, Lordship. In this
No,
case,
maybe,
Lordship,
the learned court below has assigned one region. Why the question cannot be decided at that stage?
that is right, Lordship. But in the Supreme Court has said that what falls under jurisdiction of the court. If the suit is not maintainable, that also falls under the jurisdiction of the court, and that has to be decided at the first instance by framing a preliminary issue. Well, Lordship, 2024 judgment, I will rely. Paragraph 38, 39, 41.
No,
Relevant.
can be decided, there is no dispute about the same. It can be decided.
Yes, it can be decided. And
Uh,
if
but
facts are
the-
admitted, Lordship. Paragraph 38, 39, and 41, relevant. And question of maintainability will fall under the word jurisdiction, Lordship.
So how the court has no jurisdiction to try the suit?
Because, Lordship, in this, in their plane, they have admitted that a agreement for sale was exhibited, but they have filed a suit for their tenancy right and for their permanent injunction, because as far as their plane, it is stated that they are lawful tenant under me. And subsequently, before filing our WS, we have filed a legal notice to them to vacate the suit premises. On basis of the legal notice, they have filed a reply, Lordship. On that notice, they have admitted that they are no longer the tenant under me. On that basis, it is admitted by them in their written statement against my counterclaim. That is on page, Lordship. Page 78.
Okay, okay, you tell me in which part of this decision Supreme Court has stated that
Lordship.
once preliminary issues are framed, the court has to answer the same.
Regarding this aspect, Lordship, I would like to produce another judgment of Supreme Court 2020, Lordship, 6 SCC 557. In para 61, it is said that in case facts are admitted, no doubt about it that under Order 41, Rule 2, a suit can be decided even as to the question of res judicata, constructive res judicata, and maintainability, Lordship, if facts are admitted. Because I have filed a petition on the admitted facts, because they have already admitted regarding the reply notice that they are no longer a tenant under me. On that basis, we have filed an application. Our only contention is that once it is framed, Lordship, it has to be decided either on my side or on their side. Lordship may remand the matter for fresh decision. Or Lordship may remand the matter for fresh decision on the petition, Lordship.
No, here the Supreme Court has observed that it was a pure question of law. But here in the impugned order, the trial court has observed that it is a question of mixed question of fact and law. So whether the trial court is bound to decide such a mixed question of facts and law as preliminary issue.
Because learned court has already framed the issue, Lordship, and matter has been fixed for hearing. And after that, because that order has been passed by.
No, those questions will be considered. Those issues will be considered at the time of hearing. After no, at the end of hearing.
My contention is
the
that
court has not closed the door for you.
That is right, Lordship. Because my contention is that once it has been framed, an order has been passed to hear the matter, the court is duty bound to hear it, Lordship. Without hearing.
No, is there any provision in CPC mandating the court to give a finding on the issues which were framed as preliminary?
Whether it is mandatory or not, that
yes,
that I will see, Lordship. That may be fixed after 2 days.
After 2 days.
Lordship, I have some difficulties after vacation, Lordship, if they want.
Because in this case, Lordship, no stay has been granted. That is the problem. Petition may be disposed of as far as merit. But for 2 days, I will look into the matter. I also have to go on.
I have some difficulties. I am having some eye problems for a long time, Lordship. For this matter, I have come.
No, that's all right. Only he will make submission on the point.
Only in this point, Lordship.
No, Lordship, then I have to reply some. It's because there is no jurisdictional issue to entertain the revision petition under Article 227, and that is mixed question of one fact. Order 14 Rule 20 clearly specified that all the issues may be pronounced, decided together. And if only pure question of law is there, that can be decided first as per elimination. It is order 14 rule to specifically it provides that.
Because my petition is lordship not under order 41, under section 9, read with order 41, rule 1 and 2. Under section 9, what it says, lordship.
Okay, then let it be on Friday.
Friday, lordship.
Friday. Heard Mr. Kolita, learned counsel for the petitioner, Mr. Som for the respondent. List the matter on Friday for further consideration.
Oblige.
On Monday.
Monday,
Friday or
Monday.
Oblige, lordship.
Separate.
Oblige.
Item 32.
That's what or not, that's what or not.
My mother, I probably responded. Today morning, we have filed a Ukalatnama. So I want some time, my lord. It is clear, please see my lord, transfer petition.
The last date notice was deemed to be served.
Yes, correct.
It was orally observed today would be fixed for the
Yes.
disposal of the suit.
Where the case is pending now?
Now it is from transfer Hailakandi to section, only 35 kilometers, my lord.
Is it?
It's fine.
Shaimal, actually, the petitioner herein, the lady, she has already filed a domestic violence case against the respondent, which is pending at Silchar, and the respondent has duly appeared and filed his written statement.
So list the matter. When?
Actually, the divorce case is listed as per my information on 28th of April, and there is no stay. So if it will come up immediately after vacation, it will be adjudicated.
Right.
Registrar list the matter on
24.
24.
okay, 24.
24.
24. Obliged.
Item 33.
Yes, the
Yes,
copy is available. Mr. Sharma, see whether date is there or not.
Date is there, lordship. It
Date
is
is there.
in my petition also, let's say. But that is my bona fide mistake that on that day, lordship, I could not file it.
So actually, the petition is based on false good laws.
Not for suit, lordship. I have mentioned in my petition that date is there and that is filed on that day itself.
Then it said that the service of your written statement and counterclaim was not provided on the date of filing yours. That is contained in the petition.
Now, what is this? The case is pending.
Finally, see, Lordship, paragraph number 11, Lordship, of petition.
Till afternoon, it was not filed, Lordship.
Paragraph number?
11, Lordship.
Yes.
The petition was subsequently submitted on 9/7/2025. Till afternoon, the different numbers 1 to 3 return furnish the copies of written statement come counter. And findings of the learned transport specific directly the different numbers 1 to 3 furnish copies into order of printed in the order dated 9/7/2020. So from the service copy, it is well apparent that on the date of filing, the written statement can counter before the honorable trial goes. The service copy was provided on the date that was. But he did not collect it from the case record. That is their fault. That is their fault. So, filing of written statement against the counter claim starts from 9/7/2025. And on the date of filing,
It was my notion, Lordship, that it was not furnished because in pair number 7 of my petition.
So how many days delay in filing the counterclaim? Or written statement against the counterclaim?
pardon,
How many days delay?
Lordship,
It was the 98th day, Lordship, on that day.
it was not yet filed. It is not yet filed. Little bit of passing the appeal order, it was 98 day, Lordship. On the 98th day, he had sought for adjournment.
And the same principle is applicable in case of WS also.
Yes, Lordship, order 8 foot. Order 8, rule 8 zeros. Kindly please order 8, rule 8. Six zeros. Order 8, rule 6G. Rules relating to written statement to apply. The rules relating to a written statement by a defendant shall apply to a written statement filed in answer to a counterclaim.
That's all right.
Yes.
Whether this period of 90 days, no, if the period of 90 days is not mandatory in case of written statement.
That's right, Lordship. For filing written statement, 90 days is mandatory, Lordship.
No, not mandatory. It can be, it can be extended provided sufficient reason is shown.
That is maximum period of 90 days. Filing of written statement, kindly see order 8.
No, that is
Lordship. And that is extended maximum period of 90 days, up to maximum period of 90 days.
have you gone through the decision of Supreme Court in the Salem Advocate Bar Association case?
I think.
And in the case of Koilas versus the Nanko case?
My humble submission is that I think definitely with respect to promotional, 120 pages. From
Indeed.
here all,
No, no. No. It is applicable in case of other suits also. Okay, better you do one thing, you take the decision, both the decision.
it's process.
You come at 2 p.m. We'll take it away at 2 p.m.
That's because the mechanism mentioned before trying to. So, fix that on Monday.
No, no, today we'll hear the matter. Come at 2. Only issue is you see whether those two decisions, the ratio laid down in those two decisions are applicable in this case or not.
Here, Lord, really mean partially.
Yes, next item.
Next for hearing, number 40, order meter.
The judgment is here to be. May I please, your lordship?
Yes, on the other day we left on the burden of proof.
On the burden of proof.
Yes.
And your lordship has had suggested me to go through the judgment of the Honorable Supreme Court, 2006. So the copies are here, my lord. And paragraph number 19, first I would like to read from that judgment, my lord.
So according to you, the burden of proof lies upon the plaintiff.
Yes, madam. According to me. Because, my lord, in paragraph number 10, 11, and 13, they have already alleged that I have defaulted to pay the rent from the year 2008 up to the year 2013. And the suit was filed, my lord, on 6/3/2014. 6/3/2014. So, as per Article 52, my lord, for the area of rent, it will go back only from 6/3/2014 to 3 years, which in my respectful submission before your lordship comes to 6/3/2011.
From who is that to who is that?
My lord, the suit was filed on 6/3/2014. Article 53 to some article.
Yes.
My lord, and if we are going to go back from 6/3/2014, my lord, then 13, 12, and 11, 6/3/2011, my lord. For area of rent.
Six 2011.
Yes, my lord. Now, my lord, Article 52 contemplates that for areas of rent 3 years, when the areas becomes due. When the areas becomes due.
Which article you are referring to?
Article 52, my lord, of the Limitation Act.
Yes.
And to that effect, my lord, your lordship had on that very date pinpointed about this this SCC 2006 5 SCC page 558, 558. So, my lord, it says that about the burden of proof and this section 101 and 110. My lord, had not B. Burden of proof and onus of proof. Distinction between and meaning of explained words and phrases. So, my lord, an agreement, this is the citation, an agreement to sell was entered into by and between the parties hereto. A sale deed was executed pursuant to the said agreement to sell. However, a suit for declaration was filed by the respondent plaintiff, alleging that the said sale deed was forged, fabricated, and was a void document. The question that arose before the Supreme Court was whether the trial court, as affirmed by the High Court, had correctly placed the initial onus of proof on the appellant defendant. Answering the question in the negative and allowing the appeal, the Supreme Court held a distinction exists between a burden of proof and onus of proof. The right to begin follows onus probendi. It assumes importance in the early stage of the case. The question of onus of proof has greater force, where the question is which party is to begin. Burden of proof is used in three ways. My lord, one is to indicate the duty of bringing forward evidence in support of a proposition at the beginning or later. To make that of establishing a proposition as against all counter evidence. And number three, an incriminate use in which it may mean either or both of the others. So this was, my lord, explained in detail in paragraph number 19 of the judgment. 19 of the judgment. May I read, my lord, that 19. There is another aspect of the matter which would be borne in mind. A distinction exists between burden of proof and onus of proof. The right to begin follows onus probendi. It assumes importance in the early stage of a case. The question of all those three are there. Thereafter, my lord, the elementary rule in section 101 is inflexible. Fourth line from below, my lord. The elementary rule in section 101 is inflexible. In terms of section 102, the initial onus is always on the plaintiff, and if he discharges that onus and makes out a case which entitles him to a relief, the onus shifts to the defendant to prove those circumstances, if any, which would disentitle the plaintiff to the same. Now, my lord, so in that way, that query of your lordship is answered here itself, my lord, that it is the burden on the part of the plaintiff to prove the facts of the case. And this question of limitation, my lord, the other day I raised was, it is a question of jurisdiction. It is the duty on the part of the learned trial court itself to go and see whether the court has the jurisdiction to grant that relief or not. If not, then the court is debarred from answering that question. Whereas at page number 92, I had shown on that very date to your lordship, at page number 92, while answering the issue number 5, my lord, the court has granted area rent from the year 2008 up to the year 2014, my lord. If I can take your lordship to that page.
Page number 90?
92, my lord, if I'm not mistaken. 92, my lord. The 92, from the very beginning, it starts with the order, my lord, and order number 4. I would like to read, my lord, because certain other substantial questions of law are on that. The suit is decreed on contest with cost with the following reliefs to the plaintiff, Shri Dakhin Satra, a decree declaring that the lease deed bearing registration number 6827/85 is liable to be cancelled.
let a precept be issued accordingly to the concerned sub-registry for cancellation of the original registered deed of lease bearing number 6827/85 and for recording the fact of cancellation in the official record of the concerned sub-registry. A decree declaring that the defendants are liable to be evicted from the scheduled land. A decree declaring that the plaintiff Satra is entitled to recover possession of the land of Schedule K by evicting the defendants therefrom and by re-entering into possession thereof. A decree for realization of area rent for a period from 2008 till 2013, that is for a period of 6 years, at the rate yearly rent of rupees 8,554, that is for a sum of rupees 51,324 as claimed by the plaintiff Satra. Let a decree be prepared accordingly. So far this order in point number 4 is concerned, my lord, it is without jurisdiction. Without jurisdiction. When my lord, the plea of limitation was taken, the learned trial court ought to have gone through that part, whether the learned trial court does have the power to grant a decree beyond the period of limitation.
So according to you, you are bound to pay the rent with effect from 6/3/2011.
11, my lord. 11. Because the rent was yearly rent, my lord. It was yearly rent, not the monthly rent, because the tenancy comes under the Act of 1971, Assam Temporary Settled Areas Tenancy Act 1971.
So according to you, substantial question number 1 and 3 are involved here.
My lord, 5 and 6 are directly involved. 5 and 6.
No, on the other day,
We were on this substantial question of law, my lord.
1 and
5 and 6, my lord.
5 and 6.
And so far 1 is concerned,
6
my
is
lord.
not there. 6 is not there.
1, 2, 3, 4, 5 years, 5 is wrong number. For that, the substantial question of law is whether the decree for realization of rent for a period of 6 years, that is from 2008 till 2013, can be said to be in conformity with the provisions of Article 52 of the Limitation Act, 1963, and obligor is without jurisdiction and perverse. One, my lord, your lordship has already given me a judgment in para number 101.
In view of that judgment,
Yes.
this issue is this substantial question of law is not involved.
Though it is involved, but the reason, my lord, is to be given by in paragraph number 101, my lord, that even if the first appellate court does not separately frame the points for determination arising in the first appeal, it would not prove fatal. It would not prove fatal as long as that court deals with all the issues that actually arise for deliberations in the said appeal. All the issues which are raised for deliberation in the said appeal. Substantial compliance with the mandate of Order 41, Rule 31 in that regard is sufficient. In this regard, useful reference may be made to, my lord, there was another judgment of 2017, which was taken note of, including 2006 judgment, my lord. So, I would like to submit before your lordship that whether that part is dealt with by the first appellate court or not. First appellate court or not. My lord, for that purpose, the other day your lordship was pleased to hear me from the memo of appeal whether I have raised, because after asking to Learned Sharma Sahib, the Honorable Court was pleased to ask me a question, whether that question you had taken in the memo of appeal before the first appellate court or not. My lord, all the questions were taken. And if I can take your lordship to paragraph number 6 of the memo of appeal of title appeal number 2 of 2021, my lord.
Paragraph, page number?
Page number 3 of, no, not of this memo of appeal, my lord. Memo of appeal which was submitted before
No,
the
that's
first.
all right.
Yes,
Is it not
page,
part of
page
the
number
record?
3, my lord. Page number 3, my lord. Of,
No.
of
Whether
title
that
appeal number
memo of
2.
appeal is part of this record. Trial court record.
Yes, my lord.
No, I don't. It's trial record. Eight of them.
My lord, it is in record, title appeal number 2, in the record of title appeal number 2,
Yes.
2021.
Yes.
That, my lord, page number 3. Paragraph number 6, my lord.
Okay.
Paragraph number 6. I would like to read before your lordship paragraph number 6 and 7 in order to specify. For that, the learned court below arbitrarily decided the issue number 3 to the effect that, as per Article 67 of the Limitation Act, provides that in a suit by landlord to recover possession from tenant, the period of limitation is 12 years from the time when the tenancy is determined. My lord, for the determination of tenancy, my lord, I would like to submit one thing, that first agreement, lease agreement, was of the year 1965. Thereafter, my lord, it was again made in the year 1985, my lord. In the year 1985. And that was for a period of 30 years, my lord. And the expiry is on 31, or date of termination would be on 31/12/2021. Whereas the suit was filed in the year 2014. So as per Section 111, my lord, there is no automatic determination of the tenancy unless the conditions of the tenancy are violated. Automatic termination is not there. Automatic termination can only be in the year 2021, and the suit is filed in the year 2014, my lord. Then the plaintiff petitioner shall have to show before the trial court as well as before your lordship that what were the conditions which were violated. What were the conditions which were violated? My lord, if I can read the ATP agreement. How the lease will be determined, my lord? Then I will take your lordship to that because it's an offshoot from the shoot. My lord, determination of lease. Lease is their admitted position. Determination of lease is, my lord, contemplated under section 111 of the TP Act. আরো এটা আছে তো এই সেম আরো এটা আছে না আমার টিপি আরো এটা টিপি কিন্তু ডিটারমিনেশন অফ লিজ কেনেকা contract.
Section?
Section 111, my.
Yes.
My lord, a lease of immovable property determines A is, my lord, by efflux of the time limited thereby. B is, my lord, where such time is limited conditionally on the happening of some event by the happening of such event, then by the happening of such event. C is, my lord, where the interest of the lessor in the property terminates on or his power to dispose of the same extends only to the happening of any event by the happening of such event. And then, my lord, D is by the happening of that event. So then D is, in the case the interest of the lessee and the lessor in the whole of the property becomes vested and at the same time in one person in the same right. By express surrender, that is to say, in case the lessee yields up his interest under the lease to the lessor by mutual agreement between them. And then my lord, F by implied surrender. G is, my lord, by forfeiture, that is to say, in case the lessee breaks an express condition which provides that on breach thereof the lessor may re-enter, or in case the lessee renounces his character as such by setting up a title in a third person or by claiming title in himself, or the lessee is adjudicated and insolvent and the lease provides that the lessor may re-enter on the happening of such event, and in any of these cases the lessor or his transferee gives notice in writing to the lessee of his intention to determine the lease. Thereafter, my lord, H, on the expiration of a notice to determine the lease or to quit or of intention to quit the property leased, duty given by one party to the other. Here, my lord, in this case, for the purpose of determination of the lease, my lord, a notice was given to me on 2/1/2014. 2/1/2014. That is, my lord, Exhibit 4. That I will come later, my lord.
No, whether any substantial question of law is framed on that point.
My lord, in the substantial questions of law,
So here you have pointed out about 1 and 5, and you have already argued on that point, both
yes,
the point.
yes, my lord.
So should we go? No, if
There is
no substantial question of law on this point, why should
yes,
we go
for
to-
that the substantial question, my lord, 3. For that the substantial question of law is whether the courts below were right in passing the decree for eviction of the defendants from the co-scheduled land of the plaintiff when the said co-scheduled land of the plaintiff does not tally with the land in its boundaries given in the certified copies of the deed of lease bearing deed number so and so.
That is not related to determination of the lease. If no substantial question is framed on that point, should we go to that point?
No, here in this case, my lord, lease was there, but that will not come within the purview of determination of lease as contemplated here because of the
in
presence
that
of
event,
because of the my lord.
in that event, we have to frame additional substantial question of law
My lord, your
by
lordship
giving
is
notice to the other side.
my lord, your lordship is having the discretion. What is left can also be framed now.
Yes.
Yes. So
That can be-
after hearing the matter, if my lord is pleased to frame any other substantial question of law,
yes.
I am bound to reply that. But the facts which is pleaded is the determination of lease. My lord, my respectful submission before your lordship is that those are the grounds contemplated under section 111 on which a lease can be determined. But here, my lord, in this case, section 117 is applicable because of the contract entered into between the lessor and the lessee. Only on those conditions, because there may be various parts of the lease, my lord, but my lease can only be determined if there is any violation of the conditions contained in the lease, as per section 117, my lord. As per section 117. So my lord was to say something.
Yes, Mr. Sharma, any objection in framing additional substantial question of law on this point? Determination of place,
Substantial question of law is not necessary.
not necessary.
What I have to submit is my learned friend has argued on the point of transfer of property act. But their whole case before the trial court as well as in the appellate court, the transfer of property act is not applicable.
Correct. Yes.
There will be,
True.
the lordship can see this memo with page 116
Memo of appeal before this court?
before this court.
Okay.
Good debate.
Page 116.
Yes.
Yes, further submitted that the parties are not bound by the provision of the Transfer of Property Act. That is the submission of the appellant defendant. Therefore, they have submitted the one submission before the trial court and the lower appellate court and submitted a new thing before the honorable court. That is there. There is the judgment of the lower appellate court. He has further submitted that parties are not bound by the Transfer of Property Act. If there is no bound by the Transfer of Property Act, then the temporary settle the tenancy act or any other act. As for my agreement for this is that they failed to pay the rent. Therefore, I issued notice. I filed this suit. I got the degree. Where is the law? Page 120 on the lordship kindly see. On the bottom,
120?
121. It is from the bottom.
Okay.
Line 3 from the bottom. The parties hereto has agreed to abide by the clause 2 of the agreement. Exhibit 2 is precisely provide on failure of the appellant to pay the rent to the respondent within 20th day of February each year. The agreement would be automatically determined. Therefore, they have failed to pay the rent. Therefore, the agreement is automatically determined.
Okay.
Therefore, my submission before your lordship is this. This is a concurrent finding of fact of both the courts. And there is no law point involved in a case. Therefore, the appeal filed in my land will be dismissed. And some time will be given them to vacate the property because it is a property of a Satra, big vast area. And they are occupying the vast area of land, having a tea cultivation there without paying rent to us.
Okay. But in respect of this Article 52 of the Limitation Act,
Article
in 52 of the Limitation Act, in respect of a substantial question of law, number 5.
52, Article 52 is the 3 years. Article 2 arrears of rent for 3 years. When the arrears have become due. But I claim for 5 years.
From 2008.
Because there is a continuing default. On the other day, I have pointed out the section 22 of the Limitation Act. When there is a continuation of default, then the limitation will run. Even though your lordship will see Article 67.
67, dealt with.
Oh, okay, in respect of continuation of default,
Default.
from which date this limitation will start?
But I can claim the money because
Okay.
I can claim the 3 years of rent.
Okay,
Moreover, our case is governed by Article 67, not
Hmm.
52. So let's look at the C, Article 67. By a landlord to recover possession from a tenant, 12 years, when the tenancy is determined.
yes.
By a landlord to recover possession from a tenant,
Hmm.
12 years, when the tenancy is determined. Therefore, I filed this within 12 years. They have not paid the rent since 2008 and we filed this suit 2014.
Okay. Any reply, Mr. Sutter?
Yes, my lord. My lord, when my learned senior counsel has taken your lordship to Article 67, by a landlord to recover possession from a tenant. That is for the recovery of possession, and that too, my lord, when the tenancy is determined, the learned trial court as well as the first appellate court shall have to come to the finding that when the tenancy is determined, when the period is up to 2021, and for what reason the tenancy is determined. That's why I have taken your lordship to section 111, that when the lease can be determined. Lease means when the tenancy
No,
can be
no.
determined.
Before the first appellate court, you have taken the plea that this Transfer of Property Act is not applicable.
Not applicable because of section 117 of the TP Act, my lord.
Hmm.
Because it is governed by the contract.
Hmm.
Contract, and contract is contained in the lease deed,
Hmm.
and the lease deed is only determinable in the year 2021, according to my respectful submission. And before that, if any suit is filed, it is there to show that on what conditions they have filed it. And
No.
that is, my lord, the only condition by them is that the rent is not paid.
Hmm.
So when the rent is not paid,
No, you tell me one thing, whether the suit was not filed for recovery of the possession also?
recovery of possession, yes,
Yes.
yes. So
Then,
when it is a mixed question of fact and law, my lord, it cannot be taken separately.
No, then which provision, which article will govern, 67 or 52?
Both. For the area of rent, 52, and for the determination of lease, my lord, the 67, or for the, recovery of possession, 67, both.
Hmm.
Both, my lord.
Hmm. Okay.
My lord, in the argument, we have taken your lordship's 2 minutes
No,
more
no
time.
problem.
Time.
No problem. So, any other point? No point.
No, my point is this, there is a concurrent finding of fact.
Hmm.
The appeal may be dismissed. It is a land of a subtra. My only concession before your lordship and my learned friend, that it may be dismissed without cost.
It will last. Sir.
Appeal may be dismissed without cost.
Hmm.
I am not praying for cost.
There is no question
No,
of,
I am entitled to.
there is no question of cost. There is no question of cost at all when the judgment itself is perverse. The judgment of the
No,
first.
the question is whether two article can be applied to a single suit.
Yes.
That is applicable because one is for the areas of rent and one is for recovery. Because when the tenant is landlord and tenant case, payment of rent and the eviction, both will go together. He has to pay the rent And
No,
so far
if that is your contention, then you are not entitled to recover rent from the year 2008.
my decree for, because I have to state it,
Hmm.
it is a continuing default.
Continuing default. Okay, okay,
The limitation will not run.
okay. Heard, Mr. A. Sutter, learned counsel for the appellant. Mr. Sharma, learned senior counsel assisted by Mr. Burgess, learned counsel for the respondent. Argument concluded. Judgment reserved.
It can be listed any day after bill vacation.
Okay,
I'm for the respondent, Lordship.
okay. Yes, agreed by learned advocates of both the parties, rest shall list the matter after vacation.
May that may be fixed.
So 23rd April. Lordship.
On 19th.
If it is possible on 5th of May, 5th of problem.
Standing item 33.
Yes, have you gone for the
Yes, Lord.
decision?
The person in a Salem Bar Association case.
Hmm.
Finally, at paragraph number 21, I have marked. In considering this provision, support can also be held from order 8, which provides that where any party from whom a written statement is required under Rule 1 or Rule 9 fails to present the same within the time permitted or fixed by the court. The court shall pronounce judgment against him or make such order in relation to the suit as it thinks fit. On failure to file written statement under this provision, the court has been given the discretion either to pronounce judgment against him or make such order, other order in relation to the suit as it thinks fit. In the context of the provision, despite use of the word shall, the court has been given the discretion to pronounce or not to pronounce the judgment against the defendant, even if the written statement is not filed, and instead pass such order as it may think fit in relation to the suit. In considering the provision of order 8 Rule 1 and Rule 10, the doctrine of harmonious construction is required to be applied. The impact would be that under Rule 10 order, the court in its discretion would have power to allow the defendant to file written statement even after expiry of 90 days, provided in order 8 Rule 10, 8 Rule 1. There is no restriction in order 8 Rule 10 that after expiry of 90 days, further time cannot be granted. The court has wide power to make such order in relation to the suit as it thinks fit. Clearly, therefore, the provision of order 8 Rule 1 providing for the upper limit of 90 days to file written statement is directory. Having said so, we wish to make it clear that in order to extending time to file written statement cannot be made in routine. The time can be extended only in exceptionally hard cases. While extending time, it has to be borne in mind that the legislature has fixed the upper limit of 90 days. So in exceptionally hard cases, the extension of the 90 days can be extended. Similarly, in the case of Kailash Lordship, finally, at paragraph number 46, 5 Lord, 46 Roman 5. Though order in 166 is a part of procedural law, hence directory, keeping in view the need for expedition of civil cases, which persuaded Parliament to enact the provision in present case. It is held that ordinarily the time schedule contained in provision is to be followed as a rule, and the person therefore would be by way of exception. A prayer for extension of time made by the defendant shall not be granted just as a matter of routine and merely for asking more so when the period of 90 days has expired. Extension of time may be allowed by way of an exceptions for reasons to be assigned by the defendant and also be placed on record in writing, however briefly, by the court on being satisfied. Extension of time may be allowed if it is needed to be given for circumstances which are exceptional, occasioned by reasons of band control of the defendant, and their injustice would be occasioned if the time was not extended. So, the contention of the Honorable Apex Court is that the 90 days can be extended in exceptionally hard cases. Now, in our case, Lordship, the impugn order was passed by the learned trial court on the 160 days, Lord. That is beyond 70 days of the prescribed period of filing 90 days of the written statements. 160 days, on the 160 days, the impugn order was passed. The Honorable Trial Court had extended the time.
No. In the
time up to 160
no,
days.
in the morning you have submitted that it was only 98 days.
No, Lordship. My learned friend has dictated me, so
You have submitted.
From the record, Your Lordship, from the record, it is apparent that on 9/7/2025, the written statement, the counterclaim along with the written statement was filed, Lordship. On 9/7/2025, and the impugn order was passed on 19/12/2025. WS counterclaim was filed on 9/7/2025. And impugn order was passed on 19/12/2025. So 70 days was already extended.
No, that's all right. Order was passed on 19/12/2025, but when the application was filed?
On 1912, Lordship.
Okay.
1912.
So there is the delay of?
Delay of 70 days, Lordship.
70 days.
70 days, Lordship. Again, Lordship, I am on the negligence point on the part of the plaintiff. Lordship. On the last occasion, I brought to the notice of this Honorable Court that the learned trial court has directed the plaintiff to take steps upon the defendant number 4 by way of paper publication also. And that notices was deposited by the learned counsel for the plaintiff in the court itself, which he collected on 9/8. On 8/9/2025 also. And that is apparent from the order dated 9/7/2025. By putting his signature, he had collected the process of against the defendant number 4 from the records. So on 8/9/2025, it was his duty to go through the record of the case records. Even if on 9/7/2025, he could not collect the service copy, On 8/9/2025, he ought to have collected a service copy of the written statement. So my humble submission is that from the petition is that conduct of the plaintiff lawsuit as stated by the Honorable Executive Court, there does not emerge an exceptional case on the part of the petitioner plaintiff lawsuit. That there is negligence on the part of the plaintiff lawsuit to file the written statement against the counter.
Yes, what is your explanation of 70 days?
Lordship, it was not an intentional mistake,
Pardon?
Lordship. It was not an intentional mistake, Lordship. If this petition is not allowed, Lordship, the plaintiff will suffer irreparably, Lordship. Because it is a good case for them in the trial court, Lordship. So, at least by imposing cost, Lordship. Unintentional, Lordship, because it was the compelling circumstance on the very next day, Lordship. It was sudden vacation, holiday was declared, Lordship, due to Zubin Garg's funeral, Lordship. I have categorically stated. If on that day, Lordship, record was available in the court, Lordship, I would have gone through and I could have collected, Lordship. Even in an online, Lordship, on online order on that day, Lordship, it is nowhere stated that copy has been furnished to us in our favor, Lordship. It is in page number 19 of my petition,
Okay.
Lordship.
Heard Mr. Kolita, learned counsel for the petition, and Mr. Sarno for the respondent. Argument concluded, order is in.
Question numbers 17 and 18.
Lordship, may I pray a little accommodation? Here only, Lordship, one substantial question of law was formulated, Lordship. Whether the appellants are entitled for schedule go and DTO cho, Lordship. Whether both the courts below has not given the schedule go and DTO cho to the appellants, Lordship. Now I have find that there is a non-gender issue also, Lordship, in this case, Lordship. So there is a requirement of formulating another substantial question of law on that issue, Lordship. So some
That can be considered only at the time of hearing.
Yes.
Since we were not arguing the matter today.
Yes,
let it be
Lordship.
on
So
the-
I need some time to
Okay.
formulate another substantial
Or-
question.
Ms. R. Chaudhary, learned counsel for the appellant, Mr. Deka for the respondent number. For all the
Lordship,
respondents.
in one item, I am for the appellant, in one item.
On the prayer being made by Ms. R. Chaudhary, learned counsel for the appellant, the matter is then adjourned to be listed after
Lordship, after view vacation, any date?
after vacation. In RSA numbers 172 of 2013.
159.
Mr. Deka for the
2015.
appellant here.
Appellant.
Then Ms. R. Chaudhary for the respondent. Ms. Chaudhary prays for little accommodation. Then the same is accordingly granted. Rest shall list this matter along with RSN number 159 of 2016 on
14.
14.
Question number 21.
Negligible Lordship. In this case also, Lordship, by order dated 18/9/18, only one substantial question of law was framed. If your Lordship sees the order dated 18/9/18. Whether the judgment and decree passed by the first appellate court thereby declaring the right title interest of the respondent plaintiff number 2 in respect of schedule B1 land is sustainable for non-joinder of pro forma respondent number 1 to 12 in the first appeal. But Lordship, while I'm going through the case record, Lordship, in my respectful submission, the vital substantial question of law has not been framed at the point of time, Lordship. So I have suggested another additional.
No, that can be considered only after hearing of the matter, not in advance.
The thing is that, Lordship, yes, that your Lordship is very correct, but it says that the substantial question of law to be framed, additional substantial question of law to be framed at the time of hearing, but it cannot be framed at in the judgment.
No, cannot be. At the time of hearing, if
Hearing.
it is necessary, found necessary,
Yes,
then giving notice to the other side only it can be framed.
yes.
Settled domain.
So that is that this additional substantial question of law is a very much necessary, Lordship, to determine the case because it is a judgment of reversal, Lordship.
No, that's all right. You argue the matter on merit. We'll consider if it is necessary.
Satisfied that yes, an additional substantial has to be framed. Only then. That's the second law.
Section, yes, it has to be substantial question of law. So, Lordship, I'll start from this substantial question of law, why it is necessary, Lordship. Lordship, in this case, if your Lordship sees the plaintiff itself, Lordship, at page 8.
Page 8 of the memo of appeal.
Memo of appeal.
Yes, that is a plaint.
Plaint. Lordship, kindly see the cause title of the plaint, that suit for decree declaring right title interest of the plaintiffs in the suit land, partition of the suit land to place the legitimate share of the plaintiffs under separate dak patta in the exclusive title and possession of the plaintiff by evicting the defendant therefrom. So this is a declaratory suit of right title interest and, Lordship, for partition. Now, if your Lordship sees the plaintiffs, that plaintiff number 1 was the wife of late Manohari Deka. That plaintiff number 2 is the son of Manohari Deka. Then defendant is Mridul Deka, who is the appellant here in Lordship. He is also son of the Manohari Deka. Then 1, 2, 3 are the daughter of Manohari Deka who are made the POFMA defendant, Lordship. Now, Lordship, their case is that in paragraph 1 itself, 11 bigha 0 kotha 2 lesa, it belongs to one Manhal Deka, who is the grandfather of plaintiff number 2 and the defendant. Then, Lordship, Manhal Deka in paragraph 2, Manhal Deka had 4 sons. Sarveshwar Deka, Sandhya Deka, Manohari Deka, Sri Pranohari Deka. And I'm just reading this paragraph 2, that the pattadar and the owner of the land in Schedule A, namely Manhal Deka, was the paternal grandfather of the plaintiff number 1 and the defendant. Manhal Deka died 60 years ago, leaving behind his sons, Sarveshwar Deka, Sandeshwar Deka, Manohari Deka, and Sri Pranohari Deka, out of whom only Pranohari Deka is surviving. Sarveshwar Deka died, leaving behind POFMA defendant number 4, 5, and 6 as his legal heirs. Sandeshwar Deka died, leaving behind POFMA defendant number 7, 8, 9 as his legal heir. Manohari Deka died, leaving behind the wife Srimati Sukela Deka and the plaintiff number 1 son of Munindra Deka, the plaintiff number 2 and the Mridul
Deka, the defendant. Now look at paragraph 3. Soon after the death of the Pattadar Monhol Deka, the land in the Schedule A was inherited by his son, Sorbeswar Deka, Sandeswar Deka, Monohari Deka, Pranohari Deka, and mutually divided the land in the Schedule A amongst them, plot by plot, according to their convenience and comfort. In that process, the northern part of the land in the Schedule A, covering the northern part of the DAG number 102, was placed under the exclusive occupation of Pranohari Deka, wherein he constructed his residential house and is still residing there. The middle part of the land in Schedule A covered by DAG number 102-689-100 was placed in the share of Sandeswar Deka and Sorbeswar Deka, wherein they constructed a residential house, and at present their legal heirs are residing there. The southern part of the said Schedule A, forming the southern part of DAG number 102, measuring 3 biga 1 katha 16 lesa, was placed under exclusive title of and possession of the Monohari Deka, wherein he constructed his residential house and was residing there with his family member. This 3 biga 1 katha 16 lesa of land held by Monohari Deka has fully been described in Schedule B, giving hereunder, and forms the part of the suit land. That the husband of the defendant number 1 and the father of the plaintiff number 2 and the defendant, namely Monohari Deka, died in the year 2004, leaving his wife Sukela Deka, son of plaintiff, the defendant, and his daughters, pro forma defendant number 1 to 3. Lordship, kindly note this one. The daughters have already been married and residing in their respective matrimonial homes and do not claim any part of the suit land. This is his contention, plaintiffs. However, the daughter of Monohari Deka have been impleaded in the suit to have the suit decided in their presence. That the plaintiff number 2 is serving in the veterinary department of the government of Assam. In his lifetime, Monohari Deka gifted a part of the land in the Schedule B in a plot of land measuring 2 kathas 10 lesas in favor of the plaintiff number 2 by executing the registered deed number 2664 dated 26/9/2003 to facilitate him to construct his residential house thereon by obtaining a loan from the bank. These 2 katha 10 lesas of the land has fully been described in Schedule B1, giving hereunder. That the plaintiff obtained a loan from the Praxis Gauhati Bank and constructed his residential house upon the land of the Schedule B1, which he completed in the year 2006. That the plaintiff is serving as government servant in a transferable post and has to remain away from his home as well as the land in Schedule B. On the other hand, the residential house left by the Monohari Deka got dilapidated in course of time. So the plaintiff number 2 requested permitted his younger brother, the defendant, and his mother, the plaintiff number 1, to reside there in the house building standing upon the land in Schedule B1 and to look after the house for and on his behalf. Accordingly, the defendant and the plaintiff number 1 had been residing in the house building standing upon the land in Schedule B1. That suddenly on 3/5/11, the defendant drove the plaintiff number 1 from the house of the plaintiff number 2 standing upon the land in Schedule B1. That on he next day on 11, the plaintiff number 2 reached home to inquire into and try for amicable settlement with the defendant, but the defendant denies to talk to the plaintiff number 2 and did not allow the plaintiff number 2 to enter into the house of the plaintiff standing upon the land in Schedule B1 and threatened the plaintiff number 2 not to try to enter into the house standing upon the land in Schedule B1 to avoid any bloodshed. The defendant further expressed that he would occupy and consolidated his occupation over entire 3 biga 1 kata 16 lesas of land left by the Monohari Deka. The plaintiff number 2 could not talk to the defendant and had to return disheartened. That out of the land in Schedule B, the plaintiff number 2 has already acquired right, title and interest over a plot therein, measuring 2 kotha 10 lesa as has been described in the schedule B1, and thus there remain 2 biga 4 kotha 6 lesas for the plaintiff and the defendant to share equally, each to the extent of 4 kathas 15.3 lesas. Thus, the plaintiff has number one has right title interest in the suit land to the extent of 4 katha 15.3 lesas, and the plaintiff number 2 is enjoying title in the land in Schedule B to the extent of 1 biga 2 kotha 5.3 lesas, which includes the land and house building described in the schedule. The defendant has already disposed the plaintiff number 2 from and the schedule from the land in Schedule B1 and the house building of the plaintiff number 2 standing thereon, and has been trying to dispose the plaintiff from the entire land in Schedule B as left by the Monohari Deka. From the conduct of the defendant, it appears that the plaintiffs may be deprived of his legitimate claim unless legal action is drawn forthwith, and hence this suit. Then the plaintiff do not claim any relief from defendants. Then let's say cause of action, that the cause of action for the suit arose on 3/5/11 at village so and 4/5/11 at village so and so. Then so now let's say this prayer is important. First prayer is that a decree be passed declaring the plaintiff number 1 has right title and interest in the land in Schedule B and within the suit land to the extent of 4 kotha 15.3 lesa, and plaintiff number 2 has right title interest in the land in Schedule B and within the suit land to the extent of 1 biga 2 kotha 5.3 lesas, including the house building standing upon the land in the Schedule B1 thereunder, and the decree for a partition of the suit land be passed, placing the land of Schedule B under the joint title and possession of the plaintiffs and the defendant, and thereafter to partition the land in Schedule B among the plaintiff number 1 and the plaintiff number 2, and defendant placing 4 kotha 15.3 lesas under the exclusive title and possession of the plaintiff number 1, and placing 1 biga 2 kotha 5.3 lesa, including the land in the Schedule B1 under the exclusive title and possession of the plaintiff number 2 by placing the land under separate dak patta and in exclusive title and possession of the plaintiff number 1 and 2 according to their legitimate share by evicting the defendant from the land so partition from the plaintiff, and that the specific decree be passed to deliver khas possession of the land and house building standing upon the Schedule B1 by evicting the defendant therefrom. Now here, Lordship, his case is based on 2 cause of action as per plaintiff. One is that after his death of his father by way of inheritance, and the second cause of action is by gift deed. 2 separate cause of action. One is arises on 2/2/2004, and second is on 26/3/03. So these 2 different cause of action has been clubbed, and what he prays here is for partition.
26 to
1 is Lordship 2/2/2004. So far as that on that date their father died. So after 2/2/04, right of inheritance by birth has accrued. And second is he is saying that gift deed. Gift deed is dated 26/9/03. So there are 2 cause of action, gender of 2 cause of action, and one is their recovery of possession. Now, if Lordship sees the prayer, there is no separate prayer for the land for gift deed. So the prayer for partition and right title interest, that is the main prayer, and he included both, not separately. for the cost of repetition, if I lordship to distinguish that part, because he did not speak for any exclusive or separate prayer relief regarding these two cause of action. He clubbed it. If lordship sees that the decree be passed declaring plaintiff number 1 is all right title interest in the land in Schedule B and within the suit land to the extent of 4 quota. Now, and here this is relevant. And the plaintiff number 2 has right title and interest in the land in Schedule B and within the suit land to the extent of 1 bigha 2 kotha 5.3 lesas. According to him, 2 kotha 10 lesas were gifted to him. So he clubbed this 2 kotha 10 lesa plus 4 kotha 15.3 lesa. There is no separate or exclusive prayer. It is a joint prayer. He sought for partition, which included the other this thing also. Then lordship in next degree of partition also, that is the right title interest. Degree of partition also, lordship. He says there's position of plaintiff number 1 placing 1 bigha 2 kotha 5.3 lesas including land insurance so under the exclusive title position, the plaintiff number 2 by placing the land. Here also this entire 1 bigha 2 kotha 5.3 lesa that included in the partition part. Right title interest also, partition also. And if lordship sees at paragraph 4, paragraph 4 says that the daughter has already been married and residing in their respective matrimonial home to do not claim any part of the suit land. Daughter need not claim any this thing, but they are statutorily entitled to get the property by way of inheritance. Now, to this lordship, only by a registered relinquished deed, one can relinquish the right over the property. Here simply a statement is made and calculation is made regarding this plaintiff number 1, mother, plaintiff number 2, and plaintiff number 3. Partition is sought amongst them, excluding these 3 daughters. And there is no reason for exclusion, only says that they are married, matrimonial alone, and then they need not claim. They are statutorily entitled to get their share. Then, lordship, page 12, we have filed, the defendant has filed the written statement as well as counterclaim. In written statement, we have said that it is a fraud deed, and first page itself at page 12, narrating this facts, it is said that hence the suit of the plaintiff is liable to be dismissed, declaring that instant suit is not in the proper form and proper nature. Proper form and proper nature, lordship, that in my respectful submission, that misgender part of the cause of action. Then, lordship, this next page, lordship, paragraph 13, that cause of action. Then para 2, lordship, the plaintiffs intentionally kept in dark about the other land properties of the Manohari Deka and about the share of the other first-class heirs of the said Manohari Deka, and hence the suit of the plaintiff is liable to be dismissed, declaring that the instant suit is not in the proper form and proper nature. So all the property of the Manohari Deka is not included in the suit. Only one part, and it is an admitted fact, and finding is also there in this respect. That is why I am shown that their plain portion. Then, lordship, paragraph 3, also plaintiff number 2 claim that B1 schedule land by virtue of registered sale deed, but in this sale deed it was not mentioned about the acceptance of the deed by the donee for the donor. Then even during the lifetime of the donor, namely Manohari Deka, he constructed the residential house upon the said B1 schedule land, and thereafter he resided in the said house till his death. And after his death, the said land is being enjoyed by the defendant among with the plaintiff number 1 till today. Therefore, according to law, the said Alice gift deed is void by virtue of plaintiff number 2. By virtue of it, the plaintiff number 2 cannot claim title upon the schedule B land. Then even para 4 also, Lordship, the plaintiff number 2 resided separately since 1994 in the government quarter and all. Therefore, according to section 41 of the TP Act, the defendant acquired the right of substantial owner over the B1 schedule land along with the house over it. Therefore, the plaintiff suit is not maintainable in the eyes of law. Then, Lordship, the statement are denied. Statement of the plaintiff denied. Then the real facts has been stated at page 16. So, Lordship, these are the other plots of Monohori Deka. That first at A, 7 biga, 4 kotha, 12 lesa. It is described as Schedule X in the counterclaim. Then, Lordship, B, 22 biga, 4 kotha, 1 lesa, Schedule Y in the counterclaim. And, Lordship, these lands are not partitioned. In C, we have stated Schedule X schedule land was originally stood in the name of that Monbol Deka, and this Schedule X land is not made partition among even son of the Monhal Deka. Then D also, Your Lordship, that why schedule land also not partitioned. Then paragraph E, this 2 kotha 10 lesa, it is described in the Schedule Z. So this land of Monohori Deka is not included in the partition suit. Then during the lifetime, Lordship, this F, this present suit land of the plaintiff, during the lifetime of the Monohori Deka, he peacefully enjoyed 3 biga 1 kotha 16 lesas of land from XYZ schedule land within the compact boundary, such as north so and so, south so and so, east, west so and so, where Monohori Deka constructed his dwelling house. According to defendant, it is constructed by Monohori Deka. According to plaintiff, he has constructed. He said 3 biga 1 kotha 16 lesa of land is specifically described in Schedule M. Then, Lordship, these facts are stated. This facts stated by this Lordship defendant, whole facts. What is the real facts?
No,
And accordingly,
in the case in hand, we are only concerned with Schedule B1 land.
yes, no, not Schedule B1 land, Schedule B land.
No, you come to the pair portion of the plaint.
That is what, Lordship, that is what. Prayer portion, Lordship.
Yes, B1.
No. My point is different, Lordship. Here, my point is that there are two cause of action. What is the right claim by the plaintiff? One by way of inheritance, and one by way of gift deed. So both this included in the Schedule B. And what he sought, Lordship, right title interest in the Schedule B. And he claimed his portion as 1 biga 2 kotha 5.3 lesa. And B1 is included in this. So if
there is no pair in respect of the B schedule land. Pair is only in respect of B1 schedule land.
But in my plaint, Lordship, all the B is there here. In my prayer, Lordship.
My lord, only the question is, I back to my lord, just interfere, my lord, because here, my lord, the card shop, if your lordship look into this 1911, 1989 to 2018 audience of this by which my lord is second it was admitted only on substantial question. And here, my lord, the honorable court has discussed the entire matter. If your lordship kindly look into this, my lord, here, my lord, We filed the title suit, they filed the counter claim. Both the title suit and counter claim was dismissed. Against it, we preferred a first appeal. They did not prefer any first appeal. Against their dismissal of their counter claim.
In a nutshell, this is
Yeah.
correct.
Yes.
But we have to enter the real this thing, Your Honor, which is not adjudicated by this appellate court.
They lost their right in the first appeal. They did not contest the right, first appeal, my lord, against the judgment which went against them. And that has been discussed in my lord, the 2018 order by this honorable court.
That court says
They
that
have, my lord, challenged the validity of grid tag. Court has nullified that. And only that question of law was filed. Substantial question. 89/2000, my lord, 18 order in my lord, IA.
In RSA,
194. The honorable court will discuss the entire matter.
my lord.
order 7.
You must look into 89 order. Well, may I read, lordship?
No, Lordship, that is, I'm presenting my case. He will get the opportunity, Lordship, because he will submit his part.
Yes.
But I am submitting this on the teeth of this the additional substantial question of law, because Lordship kindly see, if Lordship kindly see the issues involved. What is the issue framed by the trial court? Kindly see, Lordship. There is no substantive issue at all. At page 60. What are the issues at page 61? Whether there is cause of action for the suit. Whether the plaintiff is entitled to decree paid for. Whether the defendant is entitled for a decree as paid for in the counterclaim. Whether the defendant is entitled for a decree as paid for in the counterclaim. These are the general issues are. These are all framed in the general.
They should have taken it in the first appeal. They did not declare any appeal against that, my lord, judgment.
I am on my point
Last
that
time satisfied whether they entitled at all.
Lordship, kindly he can note it down, Lordship, and he can submit it because
No, that's not right. Mr. Deka, you see, here only one substantial question of law is framed.
yes, that is there,
So
Lordship.
you are to argue only on that substantial
No,
question of law.
I'm that is why, Lordship, I have this additional is required. Why it is required, I'm going to show that only. Whether it is required or not, whether this is a substantial question of law.
I also understand.
Yes, definitely. Because Lordship kindly see again, see before seeing this again, see the prayer, Lordship. Prayer is that because in prayer two parts are there, plaintiff number 1, plaintiff number 2. They says that excluding, why they have excluded, we have not excluded in our counterclaim. We embrace all the 3 daughters also, but they did not make them a principal defendant in this case, suit. They made them pro forma defendant. But Lordship, what according to the plaintiff, their partition is regarding 4 kotha 15.3 lesa by plaintiff number 1 mother, plaintiff number 2 and defendant, excluding the 3 daughters. And Lordship, he is claiming again that Schedule B land, which is part of this Schedule B1 land, which is the schedule part of the Schedule B land, 2 kotha 10 lesas, he claimed as a understand of the give deed. So he clubbed these 2. Now Lordship kindly see the prayer. That a decree be passed declaring the plaintiff number 1 has right title interest in the land in Schedule B. It is not B1, Lordship. In the Schedule B. And within the suit land to the extent of 4 kotha 15.3 lesas. This is regarding plaintiff number 1. Now plaintiff number 2. The plaintiff number 2 has right title and interest in the land in Schedule B.
Including.
And within the suit land to the extent of 1 bigha 2 kotha 5.3 lesas, including the house building standing upon the land in Schedule B1 thereunder. So he did not seek separate relief for the separate cause of action. My point is that he clubbed these 2.
Not long.
He clubbed these 2. And then partition part, because no right title interest is granted by this appellate court regarding this pair, and no partition is granted. by both this court. Now, second part is also same. Now, if Lordship see Order 7, Rule 8. Order 7, Rule 8 says relief founded on separate grounds, where the plaintiff seeks relief in respect of several distinct claims or cause of action founded upon separate and distinct grounds, by they shall be stated as far as may be separately and distinctly. My point is that he has two cause of action. One is by way of inheritance by birth from his father. Another is a transfer by gift deed. He clubbed two, and relief he did not state distinctly. That
So, you say, this, counterclaim is
yes,
at page number 12.
yes.
All these grounds are taken in the counterclaim that was dismissed by the trial court. That is not before any first appeal, my lord. And this is the question, my lord. This is their previous question of the claim. Our claim was dismissed. We deferred a first appeal. They did not defer any appeal. In first appeal, judgment of a trial court was modified to the extent declaring our right title interest in favor in respect of B1 schedule of land, which my father has gifted to me, which they put to challenge in a counterclaim that was dismissed counterclaim. And the trial court has filed when there is the gift deed with the challenge as null and void has been dismissed by the trial court. Therefore, dismissed by the trial court, my lord. On that issue, my lord, trial court, first appeal court reversed this finding of the gift deed. That yes, they are entitled to this property, that extent of the property by virtue of the gift deed, because the defendant put to challenge the validity of gift deed before the trial court, but you can nullify their ground, my lord. So validity of the gift deed is upheld. And by virtue of the gift deed, I entitled to the right title to investor to give one schedule of land. And whatever my learned friend is now saying, they did not take any such ground in the first appeal. They did not file any first appeal also. That was to be discussed. But in this order of 1998, my lord, that is why my lordship looked into 1998, 2009 order, everything clear. After discussing everything, only that substantial question of law was framed.
Okay, then let us go to the order.
Lordship 1998. My lordship will write the 3 o'clock. My lord, where I said 3 o'clock.
Pardon?
My lord, where I said 3 o'clock.
Yes, but in the meantime, you may complete it.
Yes, I know that my lord, it's another day. My lord, I'll submit also. But I am taking on lordship 1998, 2000 years order number. Lordship. Yes, lordship, may I read, lordship? Hard, Mr. B.N. Sharma, learned counsel for the appellant, as well as Mr. Vijay Ghosh, learned counsel for the respondent by this application under section under CPC. Then number 1 has challenged the first appellate judgment and the decree later so and so passed by the learned additional district corporate item number so and so, by which the suit was filed by the respondent was decreed in favor of the respondent number 2, namely Munindra Dekar. This is I am the by holding that he has the right title interest in possession of the B1 land and home and house standing there in the constitution. It was held that the appellant defendant number 1 named in the Dekar is liable to be evicted therefore in accordance with the law. Accordingly, the improved judgment and decree dated 23/12/2016 passed by the civil judge for better evidence number so and so, thereby dismissing the suit of the respondent was reversed. To that extent, the was granted by the appellate court. By referring to the substantial question of law to which this appeal has admitted by hearing, in view of the intent contest by the learned counsel for both the sides on the question of maintainability of the appeal, it seems to make a small observation as under
she will see. The respondent are the two plaintiffs in titles number 26 of 2011, but in the present defendant number 1. There are 12 performer defendants in the said suit, out of which from defendant number 1 to 3 are the daughter of the respondent number 1 and the sister of the appellant, and the respondent number 2, the performer defendant number 4 to 12 are the sons of the 3 remaining paternal uncle of the appellant. The suit was filed for declaration of right and interest, partition of their suit land for placing the share of the claim on the separate land and patta, for eviction of the appellant as well as for the other reliefs. The respondent claim right of the respondent, claim right of the respondent number 2 over 2 patta tables of the land. The study will be one of the claim on the basis of the registered agreement dated 26/9/2003. The state appellant challenged the validity of the said gift by filing a counter claim and sought for declaration that the all legal representative of his father, Monoli in common right, title, and interest upon the Shittul M land described in the counter claim, as well as described in the Shittul B and Shittul B1 land, described in the claim for declaration that house standing on the B1 land was common for all legal representative, representing Monoli for declaration that the for etc. So all these grounds are taken in the counter claim. Now, my lordship, the trial court has dismissed the suit as well as the counterclaim. As against the dismissal of the counterclaim, the appellant did not prepare any first appeal. But against the dismissal of the suit, the respondent, that is me, my lord, herein had filed a title appeal being TN number 1 of 2017. Under these circumstances, objection to the admission of this appeal, a preliminary issue was raised by the learned counsel on the ground that the appellant accepted the dismissal of the counterclaim without filing any appeal, either independent by or a contradiction. In an appeal filed by the respondent, a second appeal itself was not maintainable. The learned counsel both the sides were hard on the point of maintainability. The order is now burdened with the elaborate argument made it would be sufficient to record hearing that in the opinion of this court, as the gift was challenged by the applicant by filing a counterclaim, and the counterclaim had been dismissed, the dismissal of counterclaim has attained finality. Therefore, this court is inclined to accept the submission made by the learned counsel for the respondent and counter claim having been dismissed as a first step under section 96 against the dismissal having not been prepared. The second dismissal count is not met. However, this court would not preclude the appellant from challenging a finding record respect by the respondent. The contention of the counsel for the appellant that the respondent may challenge the trial court judgment by filing an appeal. The first appeal by the respondent must be constituted having filed against the trial court judgment as a whole, and it would, that is important by the act. And it would be inclusive the challenge to the counterclaim. This court find is preposterous that the challenging and the dismissal of the suit would include dismissal of the counterclaim, which is admittedly against the interest of the respondent. Therefore, there is no way that this court can accept that by challenging the judgment and decree, the dismissal of the counterclaim was also challenged by the respondent. So in the counterclaim, they have taken all the grounds. Counterclaim is dismissed. This honorable court says no, it cannot be extended. My lord, this paragraph 6 or 4 yeah, the contention of the learned counsel, I am reading again, for the applicant that the respondent has challenged the trial court judgment by filing of an appeal. As such, the first appeal by the respondent must be constituted to have been filed against the trial court judgment as a whole, and it could be inclusive of the challenge to the counterclaim. This court finds preposterous that the challenge against the dismissal of the suit would include dismissal of the counterclaim, which is admittedly against the interest of the respondent. Therefore, there is no way that this court can accept that by of challenging the judgment and decree, the dismissal of the counterclaim was also challenged by the respondent. In the opinion of the court, though the counterclaim and the suit are decided together as per provision of order 8, rule 6A. It is provided that counterclaim has an effect of the lawsuit, and it is for the same reason that the provision of order 8 rule 60 permits the exclusion of counterclaim. Moreover, the provision of order 8 rule 6D provides that if the suit of the plaintiff is stayed, discontinued or dismissed, the counterclaim would proceed. Therefore, in essence, there are two separate proceedings which are tried and decided by the common judgment. Therefore, If any party is aggrieved by the decree in the suit and decree in the counterclaim, it is provided that two separate appeal be filed. Unless the court accepts the common appeal for both in the suit as well as in the counterclaim, and therefore two sorts of court fees are required to be paid for challenging a judgment in the suit and the counterclaim, even if there is a single judgment. Under the circumstances, the submission made by the Law Council, the appellant, that the challenge to the dismissal of the suit amount to challenging to the dismissal of counterclaim is not sustainable and thus rejected. Therefore, it is held that the right of the appellant to file a second appeal without appellant remains the first appeal against the dismissal of counterclaim is not maintainable. So there is a clear binding, my. And in my humble submission, my lord, the principle of section 11 of the CP is also applying the subsequent proceeding, my lord. I will base on the judgment, my lord. Because there is a final finding of this scope. Now, he may proceed, I will then reply my.
I'm on the left.
I've taken my note.
Lordship, if Lordship takes the plaintiff itself, I'm on the plaintiff itself, and the finding of the trial court and appellate court on this point. On this point. That is why, Lordship, this additional substantial question of law is necessary to frame as provided under proviso to section 100, subsection 5. So on that point, I am showing Lordship, because here, Lordship, I am again saying, Lordship, he clubbed these two cause of action, but in prayer, there is no separate prayer. Now, right title interest was not granted by this trial court as well as appellate court. It is specifically held that partial partition is not maintainable. Whether the appellate court grants a separate relief, which is not prayed for specifically, which is required. And even this eviction also, Lordship, that eviction part also, Lordship, kindly see the order to rule 4C. Order to rule 4C says, P is the gender of cause of action, Lordship. Only certain claim to be joined for recovery of immovable property. Here is a recovery of that eviction part is there in a separate prayer. No cause of action shall, unless with the leave of the court, be joined with a suit for recovery of immovable property, except C, claims in which the relief sought is based on the same cause of action. This relief is not same cause of action. He sought for declares right title interest, Schedule B, which includes also Schedule B1. And Lordship, this second part also, partition. But
you come to the plaint.
Yes.
In pair person, where it is mentioned regarding the right title interest over the B schedule.
That is first prayer, Lordship. Declares a decree passed declaring the plaintiff number 1 has right title interest in the land in Schedule B. Kindly note that Schedule B. And within the suit land to the extent of 4 kotha 15.3 lesas. This is with regard to plaintiff number 1 mother. Now our relevant portion. And the plaintiff number 2 has right title and interest in the land in Schedule B and within the suit land to the extent of 1 biga 2 kotha 5.3 lesas, including the house building standing upon the land in the Schedule B1 thereunder. So two cause of action clubbed here by the plaintiff number 2. That inheritance part as well as that transfer part. He did not make separate prayer. Order 7 Rule 8 says separate cause of action, separate relief to be stated distinctly and exclusively. Now kindly see the next prayer B. This is the partition. That a decree for partition of the suit land be passed, placing the land in Schedule B under the joint title and possession of the schedule of the plaintiffs and the defendant, and thereafter to partition the land in Schedule B. Here is also Schedule B. Amongst the plaintiff number 1 and plaintiff number 2 and the defendant, placing 4 kotha 15.3 lesser under the exclusive title possession of the plaintiff number 1. Now say this part. Placing 1 bigha 2 kotha 5.3 lessers, including the land in Schedule B1 under the exclusive title possession of the plaintiff number 2 by placing the land under separate dakpata so and so by evicting the defendant from the land so partition. Evicting the land so partition. So right title interest plaintiff number 2 is sought for right title in Schedule B, which includes Schedule A. Then also partition of the same land. So partition, after partition only eviction. Then Lordship C. That a specific decree be passed for to deliberate first possession of the land and house building standing upon the land in Schedule B1 by evicting the defendant therefrom. So this third part comes under Order 2, Rule 4C. It is not his specific case that he is entitled for right title interest of B1 by virtue of the gift deed. That is not his prayer. He clubbed it. He clubbed both the cause of action and relief is single relief sought by both cause of action. And this Order 7 Rule 8 requires. Now, since he has fought for partial partition, trial court dismiss his suit, saying that the partial cause of action is not made, and it is admitted in the evidence part also. Plaintiff number 2 also says, yes, this portion is left out in this suit. Even the appellate court also held similarly, so far as partition is concerned. So no right title interest is given, no partition is given, and it says suit for partial partition is not maintainable. So without there being any prayer, separate prayer for a separate cause of action, appellate court give the decree regarding that 2 kotha 10 lessers of land, Schedule B land. It can, in my respectful submission, when he joined these 2 cause of action, made a single prayer, it cannot be segregated, Your Lordship, in my respectful submission. Had he made a separate prayer for the Schedule B1 land on the strength of gift deed, then it would have been a different thing, Lordship. That is why, Lordship, I have additional. This thing was made that whether the impugned judgment and decree passed by the first appellate court is sustainable in law for granting relief, which are not stated separately and distinctly as required under Order 7 Rule 8 CPC and contrary to the Order 2 Rule 4C of the CPC, while holding that no decree for the partition can be passed in the manner claimed by the plaintiff in the suit. So if Lordship claims this, because this is the only point is discussed, because I have shown no issues are there. Even the appellate court says that issue is not properly framed. But so this is the vital, in my respectful submission, substantial question of law. I'll argue on this other point also, Lordship. That other substantial question of law, because in the appellate court they are not made party. In the first appeal. Please don't interrupt while I'm submitting. So that point also, because until and unless relinquishment cannot be shown by the plaintiff, they cannot deprive. And appeal is a continuation of suit. And if Lordship sees, they did not challenge that part of the appellate, even appellate court, there is no second appeal regarding that part, partition part and right title interest part. They did not challenge that. They did not challenge that part by way of second appeal. And perversity also, that finding of this, that he took the loan for construction of house, but the bank witness says this loan is for the repairing of the house. So these are perverse, Lordship. Those are there. But in my respectful submission, this is the vital issue, Lordship. if Lordship sees the what is the relief granted by the appellate court at page 68, Lordship. '68, 44. Just the that relief what is granted. In view of the foregoing discussion and reason, the impugned judgment and decree of the learned trial court is partly modified under Order 41 Rule 33 CPC, holding that the plaintiff is entitled to have right title, interest and possession of Schedule B1 land on the strength of Exhibit 2. So, in this regard, there is no relief claim. Accordingly, defendant so and so has no right title interest.
What is your submission? No relief claimed.
Lordship.
You have submitted that no relief
No
claim.
separate relief, because what I am trying to say is plaintiff number two's right flows from two different rights. One is by way of inheritance. And one
The question is whether he has claimed any relief in respect of the Schedule B1 land.
Yes. Pardon?
No, whether no relief is being sought for in respect of Schedule B1 land.
No, not separately. When there is joint.
No, I am not asking you whether separately or jointly.
Yes.
I am asking you whether any relief is being claimed.
Yes, claim.
Yes.
Inclusively claim.
Then
Inclusive. No. But Lordship, that that other part Lordship has to see, because his suit was dismissed for partial partition not maintainable. Partial partition is not maintainable. When the suit for partial partition is not maintainable, and when there is no separate prayer regarding Schedule B1 on the strength of gift deed, then in my respectful submission, entire will go.
No.
okay, we'll see. Heard Mr. Decker, learned counsel for the appellant, Mr. Bose, learned counsel for the respondent. Argument remain inconclusive. Rest shall raise the matter again after vacation.
Yes. Whether Lordship will frame this edition.
No,
Framing, he has nothing to this thing.
no.
Why I can't.
He will,
Because
if it is, if Lordship frames this substantial question of law, then only he can
No.
argue on this point. If
No,
it is
no,
not
no.
framed,
Question is not at all required, my lord.
Now we are on the substantial question of law already framed by this court.
Yes.
but my prayer is Lordship
No,
to,
your pair may be there,
yes, no, on this point, I will place
but
certain
after
judgment.
hearing on that issue,
I'll place some judgment in this regarding additional.
maybe, you may, but not at this stage,
Lordship.
not at this stage.
Yes, lord.
So in respect of the rest of the item, that may be taken from the court master.